So let us start with the important concepts. If anybody has any questions, or if you want to add your own experiences or add your own comments, please feel free to stop in between. We can discuss that and then move on. Is the is a PDF visible?
Yeah, it's visible,
Yes,
but the size is actually.
Yes, madam, visible, but size be increased little bit.
Yes. I'm trying to do that.
Madam, you share the full screen. There's a small arrow on the border of the document.
I'm just trying to look for that arrow here. Just
no,
1 second.
It's actually once you project it, there will be a small arrow on the border.
Yeah.
Usko click karne se, I think it will help us.
Yeah, just.
Madam, on the border of the document, there's an arrow. Can you click it once? No, on the border of the document, just faculty or its dematerialized equivalent. Uska बाजू में एक arrow है, देखिए. On the border.
Where do you see this? I don't know why I'm feeling. No, this is
Okay.
like crazy.
That's a different display there for you altogether. Yeah. Okay.
Yeah. I don't understand, and this has never happened in the past. I'm usually not that technologically challenged, but
I think, ma'am, in your file on the top, 62.4% is appearing.
yeah.
So you can make it 100%. I think that should be fine.
Okay.
The size of the file,
62
point something is appearing percentage.
Yeah, now I've made it 100%. Now let's focus.
Yeah, it's better now.
Right. It's ridiculous. Just now I hope things are fine. Yes. So let us start with the important concepts or the important provisions in IBC. So this is for the benefit of somebody who is maybe looking at IBC for the first time. But since we have a mixed crowd here, I'll just go into some of the details. So insolvency, as we understand, is a state of being insolvent. So somebody who's not able to pay their debts is termed as insolvent. So even though this term may not have been defined as such in the code, but we understand the meaning. Then the adjudicating authority for the purposes of this code is the National Company Law Tribunal. So all actions which need to be taken under this code are to be taken before the NCLT. From there, the appeal lies to the NCLAT, that is the NCLAT, and from there, the appeal will go to the Supreme Court. So there's no involvement of any other civil courts or any other courts in the process. Generally, everything will go from NCLT, NCLAT, and from there to the Supreme Court. Now, the definition of debt is very important because unless there is a debt, there cannot be an inability to pay debt. So debt is defined as an obligation or a liability in respect of a claim which is due from any person and includes a financial and operational debt. So here, each word of this definition is important. You need to the liability, the word obligation, and which is due. So most important is you may have a liability, you may have a debt which is there in the balance sheet, but it should also have become due and which has not been paid. So for the for any action or to lie under this code, the first is that there should be a debt which was due but which was not paid. So that again, financial debt and operational debt, we will see the definitions. So financial debt, I'm not going into exactly what is written in the code under 5 subsection 8, but financial debt means any debt along with interest which is given as consideration for the time value of money. So typically what we understand is any loans which are given, the unsecured loans, the secured loans, the deposits which may have been received, the debentures which may have been received, or any amounts which have been received in respect of lease, hire purchase, bill discounting, and all those kind of transactions, all of them fall under the definition of financial debt. Then again, by virtue of the Supreme Court's decision and subsequent amendments in the code, even home buyers who are a class of creditors, they are also termed as a financial creditor. So that is also a financial debt. So all of these people will fall under the definition of financial debt. Understanding whether a particular debt is a financial debt or an operational debt is the crux, because whenever you are triggering any action under the code, actions for to be taken by a financial creditor and actions to be taken by an operational creditor are different. Again, the financial creditors have different rights vis-a-vis the operational creditors. So financial creditors are on a higher pedestal. So understanding the difference even before filing or initiating a case is important. And even after, once the case is admitted into insolvency, after that also differentiating between the two is very important. Then we go to the definition of a financial creditor. As we discussed, any person to whom a financial debt is owed or has been illegally assigned, such a person will be known as a financial creditor. Then operational creditor means or an operational debt means a claim in respect of provision of goods or services, including employment or government dues. So as we discussed, operational creditors are on a lower pedestal as compared to the financial creditor, but they have similar rights to initiate the process under IBC. But to understand an operational debt, it is a claim in respect of provision of goods or services. So any amount which may have been given as an advance for procuring certain goods or for availing certain services, that will fall an operational debt. Or even the other way around. So you have supplied the goods, but you have not received the money. Even that will come under the definition of operational debts. Now, government dues. So all your income tax dues, your GST dues, everything is will be falling as an operational debt. So here there is a paradigm shift between what we used to see in the earlier days in the different laws which were there before this, where the crown debts, as we used to call them, used to be always the preferential debts. But now they have been under this code, they have taken a backseat in that sense. So income tax dues, the GST dues and those kind of dues will fall under the definition of operational debt generally. Then even the employment dues. So some workers for whom the payments are due, the wages are due, the salaries are due. So employees and workers are also falling under the definition of operational debt. So in that sense, operational debt, the purview is quite wide. Everything generally will fall under definition of operational debt, something which is not given as a loan in the which is not shown as a loan in the balance sheet. Now, operational creditor is somebody who has to whom the operational debt is owed or has been legally assigned or transferred. Again, similar kind of definition. So we have seen what is a debt, we have seen what is a financial debt, what is an operational debt, and these two types of creditors. Now let us see the corporate debtor. So corporate debtor means a corporate person who owes debt to any person. So that person needs to be a debtor and it needs to be a corporate. Debtor as in somebody who owes debt to any other person. And a corporate person means a company, LLP, or any other person which is incorporated with limited liability. Now here, as of now, whatever actions have started taking place are against the companies and LLPs. Other kinds of entities, generally cooperative societies, and those are still not covered. Actions have still not been initiated against them. So LLP has not, the NCLT has not allowed actions against those type of entities. But against companies and LLPs, both are at par, both are falling under the definition of corporate persons, and any action for initiating insolvency can be initiated against a company or an LLP. Now, default. So one thing we need to understand here in this code is that this code is not for recovery. So the main reason why this code is brought into is not to act as a recovery mechanism, but it is brought in to try to do a revival of the company. So earlier we had many other laws which were there which used to help us, or even today we have those laws which are there for recovery suits or other things which may be there in the civil process. But this particular code is not for recovery of amounts from the debtors. This is for trying to give a chance to of revival for those companies or those LLPs which may be in default, but there is some potential that the chance may be given that these companies can be revived. And if that revival does not take place within a stipulated time period, then those companies will go into liquidation. So it's kind of weeding out the rotten apples before a lot of time passes, and kind of stemming the rot at the nip it in the bud kind of thing. So in case till now whatever actions have been taken place are historical actions, but going forward when we see that now what banks and other people are doing is that as soon as the account becomes an NPA, they are opting to go for these actions. So the values don't deteriorate. There's not a lot of time doesn't pass. Accordingly, it is a kind of easier or more beneficial in that sense to be able to recover or initiate this action. So even though it may not be a recovery process as such, but still these people are able to get better values or get better resolution for these entities. So with this background, again coming to the concept of default. So why default is important is because the trigger under this code is the default. So we have seen the debt. So whenever there is a debt which has been outstanding and that debt has not been paid when it was due, then it becomes a default. And unless there is a default, there cannot be any action which can be initiated under this code. So first is where you need to have a debt. That debt should be due and payable. And then that debt, there should be a default on that debt. So unless these criteria are satisfied, you may not be able to initiate any action under this code. Now, default is, again, each word in this definition is important. Non-payment of debt when whole or any part of installment of amount of debt has become due and payable and is not repaid. So that amount of debt, whether in whole or in part or a part of some installment, has become due and has become payable, but it is not repaid by the debtor, then only it is termed as a default. So the first thing what we need to prove if you want to file a case or initiate any action under the code is that there was a debt. It was either a financial debt or an operational debt, and that there has been a default which has been committed by this corporate debtor, and that corporate debtor should be some entity which is covered under this code. So once all these criteria are satisfied, that is where any action can be initiated. Now we come to the concept of demand notice. Now, as we have seen, either of these two people, an operational creditor or the financial creditor, can initiate any action under the code. In case of a financial creditor, it is generally pretty simple because generally it's a loan, or the banks or the financial institutions would have given certain loans to the company. Those loans would be in default, so which is clearly seen from the records. And accordingly, it may be simpler to initiate any action as a financial creditor. However, in case of an operational creditor, before initiating or filing the petition with the NCLT, one step has to be undertaken, which is sending of the demand notice. So the operational creditor, a format is specified. In that particular format, the operational creditor needs to send out a demand notice saying that such and such amount is due from you, and either pay it within these 10 days or show that you have already paid, and that there was some pre-existing dispute. If all these things are not there, then after 10 days, the operational creditor can initiate the action against the corporate debtor. But that step of sending out the demand notice is mandatory. Now, who can initiate this process? Of course, as we have seen, the financial creditor, the operational creditor, and the corporate debtor itself. So now, if you want to close down a company, or if you want to stop the operations, or if the corporate debtor feels that it is in default and it needs a chance to revive itself, there are various other advantages also, which we will discuss of going under this code voluntarily. So here, the corporate debtor itself can also initiate its own process and say that I am under default and please give me a chance to revive. So it's not only the creditors who can initiate, the company itself also can start the process under Section 10. Now, dispute. So as we discussed, the operational creditor can initiate the process only after sending out a demand notice. And that operational creditor will be successful in his claim before the NCLT only if he is able to prove that, of course, that there was a debt that debt was due and payable and it was not paid, and that is an operational creditor, but also that there is no pre-existing dispute between the parties. So since this is not a recovery mechanism, we again come down to the fact that whether this is a real case of insolvency or not. So insolvency would mean the inability to pay debt. In case there is a pre-existing dispute between the parties, say the quality of material which was supplied was not good, or for any other reason, it was not timely, there could be any other reason why that amount was not paid. So here it is not a case of insolvency, but here it is merely a case where the goods or services were not satisfactory, the quality was not satisfactory, because of which the amount has not been paid. So this is not a case of insolvency in that sense. Hence, in the biggest defense which a corporate debtor has against an action by an operational creditor is that there was a pre-existing dispute. Now, this pre-existing dispute means that dispute should be existing before the date when the demand notice was sent. So after the demand notice is sent and after that raising some dispute that your material was of substandard quality, that does not help. That dispute should have been previous in time. That means it should be pre-existing when the demand notice was sent. Now, for showing that dispute, it is not necessary that you should have that there should be a suit filed or there should have been some arbitration proceedings going on or anything. Even if there are emails which are exchanged between the parties or any correspondence which is exchanged between the parties, which say that which the CD is able to show that here they have brought it on record that your quality of goods and services is not up to the mark, or it is substandard, or it was not timely, or whatever the other dispute may be, and because of which this payment is not being made or whatever. All this correspondence is termed as a pre-existing dispute and can be used in the NCLT to defend the case. So it is not necessary that there should have been some legal notices or some cases which have been filed in the courts. Merely basis this correspondence, the CD should be able to defend this case successfully. So that is a pre-existing dispute. Then we come to the term called insolvency commencement date. So once all these cases are filed, the NCLT will hear those cases and decide in case if the NCLT feels that this is a fit case of insolvency, where all these criteria are satisfied, then the petition will be admitted. So on admission, that is the date when the insolvency will commence. So that is known as the insolvency commencement date. So irrespective of who has initiated the petition, whether the financial creditor, operational creditor, or the corporate debtor itself, anybody who initiates these particular process, they will, once the application is admitted by the NCLT, that day will become the insolvency commencement date, and all your other timelines which are there in the process will be calculated based on this particular insolvency commencement date. Now, once the insolvency commences, from that day onwards, the interim resolution professional, so somebody who is an IP who has qualified the exam and who's registered, will be eligible to be appointed as an IRP. Generally, the name is to be given in the petition which is being filed with the NCLT. So they will appoint somebody from whose name has been given. If some name has not been given in case of an operational creditor, then the NCLT has a panel and they will appoint somebody from that panel to act as an IRP for this particular case. Now, this IRP is appointed only for a temporary period, as in till certain specified actions are taken, because of which this position is known as an interim resolution professional. Which brings us to the definition of resolution. So resolution means the process of trying to revive or restart the corporate debtor. So resolve the debt basically. So that is why it is known as a resolution. Then CIRP, generally known as the corporate insolvency resolution process. So which in the stages, once the insolvency commences, that is when the CIRP process will commence. Public announcement is the notice which is issued by the IRP for inviting claims from various stakeholders. So creditors need to file claims with the IRP so that the IRP is able to prepare a list of creditors, understand who are the creditors of the company, what are the categories of creditors of the company, and accordingly he'll make list of operational creditors, financial creditors, and so on. And then based on these different lists which he has prepared, then he will start taking the further actions which are to be taken there. Then the concept of moratorium. Moratorium we generally understand where something is not allowed in that particular period. So here also, in case of an insolvency, once the insolvency commences, this moratorium will kick in. So this moratorium is there for a specified period, and it is there on specified actions. So those actions we will see. It is a very important provision in the code within which many things cannot be taken or cannot be done during the CIRP. Going concern is we understand the concept of a going concern where a business is being carried on, and this has relevance because in case an entity is a going concern, it is the duty of the IRP and the RP to ensure that the company maintains its status as a going concern. So the operations should not be hampered. So as an IRP or RP, your role is to ensure that the company continues its activities in whichever form it was going on when the insolvency commenced. Essential goods and services are again an important relevant concept, is where those goods and services which are required to keep the corporate debtor a going concern. So during the course of insolvency, the company's operation should not be carried out, should not be, they should not be hampered. And for carrying on these activities, these essential goods and services, that supply should not be disrupted. Claims, again, claim, as we understood that these creditors have to come and file claims with the IRP. So these claims are again defined properly, but generally understood is where the creditor needs to file in a particular format this claim, whether as an operational creditor or as a financial creditor, and to show that what is the basis on which he's claiming this amount from the corporate debtor. So the formats are there and everything is there for each type of creditor, and he will have the creditor will have to file the claim in that particular format and try to show along with supporting documents why such and such amount is due from the corporate debtor and what is the basis for his saying that. Then next is a committee of creditors. So committee of creditors, a parallel may be drawn to a board of directors kind of. So once the IRP is in charge of the affairs of the company on the insolvency commencement date, he will invite the claims and he will have a list of financial creditors. All those financial creditors who are not related parties, of course, will form part of that committee, and that committee will be taking the decisions in the process. So what all happens in the process will be with the approval of the committee, all the major decisions. The day-to-day things the RP can take care of, but the decisions as regards the resolution process will be taken by the committee of creditors. Information memorandum. So information memorandum is kind of a loosely termed a prospectus. So something's a document which gives the information about the company, about what are the operations, what are the locations, what are the assets, what are the liabilities, all that kind of information about the company, what products it manufactures or it deals in, what are the activities, the locations, different locations which it may have or across the country or overseas, and the number of employees and all those things. That information will be given in the information memorandum. So basically that is a kind of a document which will be shared with a prospective investor to enable the investor to take a call whether he wants to actually invest in this company or take over this company under this insolvency process. So that document generally needs to be, I mean, of course, it is drafted by the RP, but generally based on the information which he collects during the insolvency process, based on whatever information is available with him. Then coming to a resolution applicant. Again, loosely termed resolution applicant is a potential investor, somebody who wants to take over this company in this resolution process and who will submit a plan about how he wants to revive this company. So such a person is known as a resolution applicant. Request for resolution plan is a document which is again prepared by the RP, approved by the committee of creditors, which gives information about to a potential applicant, to a potential investor, as to how the resolution plan is to be drafted and what all should be the contents. What is it that the committee of creditors is expecting from that plan, and of course the other legal terms and conditions about the binding nature of the plan and all those things. All those documents, all those contents are there in the RFRP. Resolution plan is the document which is submitted by a potential resolution applicant to the committee of creditors for their approval, showing or trying to give details of how he plans to revive the company, how much money is going to put in and in what manner, in how much time and all he's going to put that money in, and how he plans to revive the corporate debtor. Then a registered valuer. Registered valuer is again there are for each asset class, the IRP or the RP is required to appoint valuers, and because he needs the latest valuation of the assets of the company. So for each category, say plant and machinery, land and building, and the securities and financial assets, we need to appoint 2 registered valuers for each category of assets, and each of those valuers will give their valuation report. And but those valuers should be registered with the IPBI as a registered valuer. Then the resolution process cost is the costs which are incurred in the course of insolvency. So anything which is any amounts which are incurred for the resolution of the corporate debtor, those costs will be are known as the resolution process cost. And these It is important which all costs are being categorized as the resolution process cost, because this has a bearing later on. When the amount is being recovered from the resolution applicant, the resolution process costs are also recovered from the resolution applicant. So this entire process, whatever expenses the committee of creditors is meeting for carrying on this resolution process, will be reimbursed to them in that sense. Now coming to the concept of liquidation, we understand is a process where the assets are sought to be realized and the liabilities to the extent possible are to be paid in that. Now in this process, since this is a time-bound process, the CIRP does not continue endlessly. It has some outer time limit. And once these time limits are met or any of these events happen, then the company will be put into liquidation. Then the again voluntary liquidation, although this code is an insolvency code, still the concept of voluntary liquidation is also covered into that. Basic difference between a voluntary and any other type of liquidation is that in case of a voluntary liquidation, the company is able to pay its debts. So the starting point for that is where the solvency declaration is given by the board of directors, where the company is able to pay its debts, but still it wants to close down. That is where the voluntary liquidation will come in. However, this is dealt with in this code, section 59, because other concepts and other regulations are similar. So again, this section 59 read with the voluntary liquidation regulations deals with the process of voluntary liquidation. Earlier, it used to be in the Companies Act. Now the Companies Act provisions are done away with, and we only need to refer to section 59 and the voluntary liquidation regulations. Now there is something known as a waterfall mechanism. So waterfall mechanism is given in section 53 of the code, which talks about the priority and the manner of distribution of the amounts which are there with the liquidator. So this is applicable to a voluntary liquidation as well as a CRP liquidation. So what is the priority in which the amount which is available within the liquidation estate, how the amount should be distributed, in what manner and in what priority, that is given in section 53. Now the concept of guarantors, we understand personal guarantors or the corporate guarantors, somebody who has given a guarantee or as a surety in a loan which is availed by that company. So these personal guarantors and corporate guarantors are also dealt with under the code. Now the provisions have been made effective for personal action against personal guarantors. Although there is some dispute which is going on, it has been challenged in the Supreme Court. Still, there are some NCLTs who are at least going ahead and hearing those matters. Maybe not finally deciding them, but action against personal guarantors again can be initiated under this code itself. Action against corporate guarantors can be initiated already because it covers companies. So generally company or LLP, if it is a guarantor as a corporate guarantor, it gets automatically covered under the code. Related parties, a very wide definition which is given in section 524 and 524A. Related party with respect to a corporate debtor and an individual. So this definition again, as we see in different laws in Companies Act or any other law, related party definition is very critical because it differentiates certain individuals, and the transactions with those individuals automatically come into the scanner. So that understanding who is a related party is very critical. Again, this related party is relevant because in most of the cases that a related party may not be able to act as a potential investor, unless there is some exceptions which are there. But identifying a related party, again, their composition or the inclusion in the composition of the committee of creditors and all that is critical. So identifying related parties is really important. Then the last concept as such is the avoidance transactions. In the course of this insolvency process, or even in the liquidation process, as RPs, we need to identify the certain transactions which are defined in the code from section 43 onwards. So these transactions, basically what we are trying to do here is we are trying to identify the reasons why this company went into insolvency, or why is it in this particular financial position. In that, one of the main reasons could be that this company has entered into, or the management of the company has entered into these questionable transactions because, or say siphoning of money or making payments to related parties, or taking out money, diverting money to other group entities and all those things. So these type of transactions are something which may have led to the insolvency of the company. So as RPs, we are required to find out whether the company has entered into these transactions in the relevant period. So the period has also been defined. For related parties, it is 2 years. For non-related parties, it is 1 year before the insolvency commencement date. And these transactions, we need to go through the books of accounts. We need to go through the records of the company, find out whether these transactions are there, whether some preference was given to any related parties or anybody else, because of which they have been put in a better advantageous position as compared to the other creditors. So that is the crux, that whether somebody has got any undue advantage as compared to what they should have got in the normal course of business. So again, identifying these transactions is one of the primary duties of the RP, and it is mandatory for each case. So there is no exception. Either you may do it yourself, or you, with the approval of the COC, you may appoint an external party to do this do this audit. But we need to do this audit, and we need to report on this to the NCLT as well as to the IBDF in case we find certain transactions. So these are the these were the important concepts which were there just for introduction. And now let us go to the process as such in detail. Yes. So as we discussed before, this IBC came in December 2016, there were different laws which were there who had which had very little impact, or there were different laws depending upon the geographical location also of the where the company was situated. So this there were different laws which dealt with individuals, and there were different laws which dealt with corporates. Again, and respect of an individual, where the location of the individual is, whether it was in the presidency town of Bombay, Delhi, Calcutta, and Madras, or the person was situated elsewhere. Then, depending on that, the action to be initiated, the court would be decided. So, in presidency towns, the action would used to lie with the high courts. If it were in other places, if the action used to lie with the civil courts. Now, in respect of corporates, again, they were divided into companies and statutory corporations. Statutory corporations may have their own different regulations. But in case of companies, again, they were differentiated as SIC companies and other companies. SIC companies, if there was a SIC Industrial Companies Act, which of 1985, which used to be there, which used to deal with the SIC companies, or companies which are not able to pay their debts. And then they used to, once they got the tag of a SIC company, the promoters used to get a moratorium, and that moratorium was never ending. There was no time limit generally which was there on for how long that moratorium used to continue, and their promoters and many people have taken a lot of disadvantage of those provisions. So to curtail all those things, and again we had these provisions in the Companies Act where for inability to pay debt and for other things we had to go to the High Court for closure of companies. So all these laws have been consolidated, and everything has been brought now under the Insolvency Code for in the concept of insolvency. Now, if you still want to close the company under the just and equitable grounds or other things, you still have the recourse to Section 271 of the Companies Act, under which you can still file a petition with the NCLT, get a provisional liquidator appointed, have the process, and then continue with the liquidation. So that 271, that those provisions are still there. In case of inability to pay debt, we take recourse to the IBC. Even in case of voluntary winding up, we take recourse to the Insolvency Code. Now, a snapshot of the insolvency adjudication process under the IBC. So, in case of corporates and non-corporates, again, there's a difference. In case of corporates, right now it is dealing with companies and LLPs, as we saw. The action will go to the NCLT. From there, the appeal will lie to the NCLT, and from there, it will go to the Supreme Court. In case of non-corporates, that is in case of individuals and partnership firms, the action will be initiated in the DRT. From there, it will go to the appellate tribunal, and from there, it will go to the Supreme Court. These provisions are yet to be made effective in respect of other individuals and partnership firms. The provisions in respect of personal guarantors only. So personal guarantors to corporate debtors. So since the corporate debtor or the corporates fall under the NCLT jurisdiction, right now the personal guarantors provisions also fall with the NCLT. So the jurisdiction also lies with the NCLT. But whenever this code is made applicable to other individuals, so who are not non-personal guarantors and partnership firms, that those actions will lie with the DRT. Those provisions are there in the code, but they have not yet been made effective. Framework of the code is, of course, the first few sections, the scope and extent of the code and the basic definitions and all get covered in sections 1 to 3. Part 2 deals with the insolvency resolution for the corporate person. So the CRP process is dealt with in part 2. Part 3 deals with the bankruptcy for individuals and partnership firms. Now, these provisions only to the extent of personal guarantors are made effective, other provisions are not. Part 4 deals with the administrative matters like the regulation of insolvency professional, their agencies, the entities, who can be an IP and those things. So all those are covered in part 4. Part 5 are the miscellaneous provisions, and then there are different schedules. So these schedules are pertaining to the corresponding amendments which have been brought in to different acts. So say the Companies Act was amended, Income Tax Act was amended, and so whichever acts are amended, those things have been given in the schedules to the Insolvency Code. What all is covered and what all has the changes which have been brought in. Of course, this deals with the insolvency of companies and LLPs. It deals with the revival of companies and LLPs in a time-bound manner, as well as liquidation, as well as voluntary liquidation. This also talks about the actions which can be taken against personal guarantors to CD. So all these is the scope of the code. Again, dealing with the new category of professionals which was not there before 2016. So anybody who is a CA, CS, ICW advocate or having sufficient requisite experience as prescribed, they need to write an exam and undergo the training which is prescribed, and after that we are eligible to act as IPs. So again, in my view, of course, the jury is still out whether this code is working, it is not working, and I think in my view, personal opinion, this is primarily if you look at the code per se, yes, the code works. The implementation may be a question, maybe strengthening the NCLT or those things will definitely go a long way in getting the real success of this code. But technically or theoretically, if you see what works for it is that this is a process where the creditor is in control. So if you see the Sikh Industrial Companies Act, it still used to be the promoter who was driving the company, enjoying the moratorium and all those the tax holidays or the EMI holidays and all those things. But here the creditor is in control. On the commencement of the insolvency, that day the promoters lose their power, so they're out of management. The IRP, who is a third party professional, who is an independent professional, he comes in and he takes over the control of the affairs of the company. The bank accounts are out of the control of the promoters on day one. So that is a huge deterrent in that sense for making this code work, or either people trying to pay up or trying to avoid this insolvency process in that sense, or even if the company does go into the insolvency, then trying to revive because somebody else is in the driver's seat. It is the committee of creditors who's going to take the decisions, and they are obviously they're interested in the recovery also as well as the resolution of the companies. But then this being in a time-bound mechanism kind of thing, it definitely helps. Recovery, yes, to some extent it does help. So especially in case of operational creditor cases, we have seen that once the case is filed in the court, usually settlement does take place. Sometimes settlement also does take place as soon as the notice is issued, the demand notice is issued. So in that sense, yes, even though the intent may not be a recovery mechanism, it is leading to certain recoveries also. And the response from legislators. So here, in case you have there's a need which is felt that some amendment is required. It's a new code, so we're just hardly 5 or 7 years old, and the response from the legislator in making timely amendments, even though it may be a nightmare for us sometimes to keep up with the amendments, but yes, that is there. So which at least takes care of the industry needs in that sense. Now let us deal with the process in detail. Most of it we have covered when we were discussing the important concepts, but we will just cover the further intricacies of the process. So as we have seen, the trigger is the default. So default, we understand, is where there was some amount which was due and payable, the debt which was due and payable, but which was not paid. Presently, the minimum amount of default is 1 crore. Previously, before COVID, the amount was 1 lakh. So you can imagine with the amount, such a low amount, how many cases would be filed, especially operational creditor cases. Now, in the COVID period, as an exception, this amount has been increased to 1 crore, but it has not yet been reduced. So as of now, for any action to initiate, the minimum default amount after 24th March 2020 should be 1 crore. Now, again, there's a debate whether this should include the interest or not, based on the different judgments which have been passed by various courts. In case that interest has been provided for in the contract between the parties, then it will form a part of the debt. Otherwise, any interest which is generally being charged and or claimed, and if that is being used to reach the amount of 1 crore, that may not be acceptable. Now, the default is to be proved based on the documentary evidence, say the bank statements. So you show where the debt was given, but this amount was not paid and all those things. Then again, what is important is how the amount of default has been computed. So that explanation needs to be given to the NCLT when along with the petition which is being filed, that how that amount has been computed and up to what date. So there's a cutoff date which you need to take up to that date, say the date of filing of the petition. What is the amount of default which is there, and then those documents along with supporting evidence needs to be placed with the before the NCLT. Now, even if the corporate debtor is filing the case, there's a long list of documents which needs to be filed in case of a section 10 petition, where the complete books of accounts, the complete list of all the operational creditors, the financial creditors, everything needs to be given to show that the company is actually in default. Now, as you've seen, the application can be filed by a financial creditor, it can be filed by an operational creditor or by the corporate debtor itself. So for a FC, the application will lie under section 7, for an OC, it will go under section 9. And in case of a CD, it will go under section 10 of the code. So this operational creditor, we have seen that the prerequisite is that demand notice should have been sent. That demand notice, once it is sent, they have to wait for that 10-day period, and after that they can file the petition with the NCLT. For financial creditors, there is no such requirement as such of having of any statutory demand notice to be sent, but generally the banks or the financial institutions do send a demand notice in that sense, where they are to invoke the guarantees or for any other action. As soon as there is a default, they will send out their notices, which is the standard practice. So those documents are also to be annexed to the petition, along with the supporting, say, whatever the loan agreements, show the ROC records, where the charge was created. All those documents can be shown in support of the fact or to support of the claim that this amount is due and payable to this particular creditor, and where this amount has not been paid and there is a default. So of course, formats are prescribed for each category of creditor. The application needs to be in that format only. The demand notice which is prescribed has to be in that prescribed format only. Any deviation in that, and it may lead to a case where the demand notice itself was faulty. So any action which arises out of that demand notice will also be automatically termed as faulty. So we have to be very careful when we are sending the demand notice, and looking at whatever supporting documents which are to be given. If something is not disclosed or something, then it is bound that the other side is going to come and bring those facts on the record. So make sure that everything, if you have been able to recover some amount from the creditor, from the debtor, disclose all those amounts and then say how much amount is due. So complete disclosure is required there. Similarly, in the case of a corporate debtor, the financials and the list of creditors, everything, the supporting documents, why there was a default, since when is the default there, all those documents will have to be given along with the petition. So that's a section 10 petition. Again, it has a different format. In case of a financial creditor and in case of a corporate debtor initiating the petition, it is mandatory to suggest the name of an IP who will act as the IRP. So the name and the consent of the IRP needs to be given in the application form. In case of an operational creditor, there is an option that they may not give that name. I may not suggest the name in the petition itself. But then in that case, the NCLT will appoint somebody from the panel which is maintained. So each NCLT has a panel of IPs. Every 6 months that panel changes. And based on the geographical location, generally the NCLT will appoint somebody for a corporate debtor depending upon where the registered office or where the office of the corporate debtor is located. Now, once the application is heard by the NCLT properly, there will be arguments and replies and everything will be filed. Once that is heard, then the application will either be admitted or it will be rejected. If it is rejected, then there are different reasons for rejection. Say maybe it was the grounds of limitation, the action was not initiated within the limitation period. Then the amount which is being claimed or as due is not certain, or is some excessive amount is being charged, so it is not meeting the threshold. Or if the opportunity of being heard was not given to the corporate debtor, so it was an ex parte order. Those things, the petition might get rejected. Already, if the corporate debtor is undergoing the CRP because of some other petition which was admitted, then this petition can be rejected. Or if there is a pre-existing dispute, like we discussed in case of a section 9 petition, the existence of a pre-existing dispute before the demand notice, that will definitely lead to a case where that petition will be dismissed because of the pre-existing dispute. In case it is admitted, then of course the CRP will commence, and that will be the insolvency commencement date. As soon as the application is admitted, the moratorium will kick in from that date. So the IRP will be appointed on that date generally, and the powers of board of directors will be suspended from that day and will have to be taken over by the IRP. The IRP is now required to go and take custody of all the assets of all the offices of the corporate debtor, take charge of the affairs of the company, and now the officers and managers of the company will have to start reporting to the IRP. The everybody, the employees, the directors, everybody is expected to cooperate with the IRP. Else there is recourse under section 19 with the NCLT, where he can go and file an application and say that seeking cooperation and seeking information, whatever may be required. Because as IRP, since we are required to take over the company, we need to know all the details of what is happening in the company, whether it's a going concern, not a going concern, what are the locations. So all this information we may be able to get only from the directors or from the financial creditors. So in that sense, cooperation of the promoters and cooperation of the personnel of the corporate debtor is a must. Then the banks and financial institutions need to start acting on the instructions of the IRP. So the bank signatories are changed generally immediately. And whatever information is sought by the IRP, that information needs to be given to him. He will also make the public announcement, and the creditors will be required to submit the claims to the IRP within the stipulated period. Now the concept of moratorium. As soon as the moratorium, this is section 14. So as soon as the insolvency commences, the moratorium kicks in from the date when the NCLT passes that order. It will continue till the completion of the CRP period, or approval of the resolution plan, or the passing of the liquidation order, whichever is earlier. So till that time, so the other difference is that this moratorium will be only for a time-bound period. It cannot continue eternally. Then during this course of moratorium, the supply of essential goods and services cannot be terminated, suspended, or interrupted by that third parties, provided of course that the corporate debtor pays for such services. In case the CD is not able to pay for those services, these will form part of the insolvency cost and will have a priority over other payments. Now this moratorium is with regard to, again, behind the moratorium, the idea is that we as IRPs, we are acting, we are third parties who have come in laterally in that sense. We don't have much information about the company. We are trying to find our feet. We are trying to take over the affairs of the corporate debtor. And our primary focus as IRP or as RP is to try and revive the company. In addition to managing the affairs, we need to try and revive the company, find a potential resolution applicant who will take over. So in this period, we should be able to focus primarily on these aspects rather than dealing with the cases which may have been filed against the company or dealing with other things. So this moratorium is primarily for prohibiting the institution or continuation of any suits, including execution of decrees, judgment, or orders which may have been passed against the CD. So of course, the CD is in problems because of which the insolvency has started. So there may be a number of cases which are there, which are pending against the company. If the IRP or RP is made to deal with those cases only, he may not be able to focus on the insolvency process, the resolution process. So there is a complete stay on the filing of new suits or the continuation of existing suits, or including the execution of any orders which may have been passed during this moratorium period. So nothing will happen in that sense. Moratorium is also for prohibiting transfer, encumbering, alienation, or disposal of any assets. Again, as we saw, the process is of revival. We want to try and revive the company. In case the assets are allowed to be disposed of or alienated during this process, then any potential investor who is coming will see lesser value in the CD. Because of which there is again this moratorium on any type of dealing with the assets of the corporate debtor. Then the moratorium also prohibits any action to foreclose, recover, or enforce any security interest in respect of property, including any action under SARFAESI. So any banks which may want to take any action of foreclosure of their security interest or anything, again during this moratorium period, they will not be allowed to do that. Again, focus is on the revival. The assets of the company should be available for this resolution process. If the corporate debtor is in possession of certain property which does not belong to him, but maybe which has been leased by it and taken on lease from some other parties, then during this moratorium period, that even though the rent may not be paid, the other party, the third, the lesser who may be there, he will not be able to recover this property. So suppose the company has taken an office or a factory on lease, and during this during the moratorium period, the landlord will not be able to seek possession of this property during the moratorium period. Again, idea is that the company should be able to function properly during this resolution process so that a revival may be attempted for that. Now the provisions with respect to appointment of IRP and the public announcement. So as we discussed, the name of the IRP has to be proposed in the application. He must be eligible to be appointed. So the eligibility check has to be done that there is no conflict of interest, and the consent has to be given accordingly. The IRP is generally the tenure is 30 days, so till the first COC. He will have all the powers of the management of the corporate data, and he has to make the public announcement within 3 days of his appointment. He has to receive the claims from the various stakeholders and collate those claims, try and verify those claims and form list of various creditors. And he has to manage the affairs of the company as a going concern. If it is a going concern, he is not expected to start the actions if the company is already dead. But if it's a going concern, he has to ensure that the company remains a going concern. The format for public announcement is prescribed. Again, the timelines and the formats are sacrosanct. We need to follow them to the T. The public announcement should be made, and which will specify in that format what is the last date for filing of claims, date of when those 180-day period. So the CRP generally for 180 days. When that period will come to an end, then the general particulars of the company based on the master data. Some statements regarding penalties for false and misleading claims. So if somebody makes a false and misleading claim, what are the actions which may be taken against that person? And the details of the authorized representative who is to be appointed. Now, this authorized representative concept will generally come in cases where there are classes of creditors. So there are debenture holders, then there are deposit holders, there are home buyers. So these are all known as a class of creditors. Now, if there are, they will generally be in large numbers. So all of them, since they are categorized as a financial creditor, they will they have a right to sit on the COC. But accommodating all of them as those as in number, in volume, is not feasible. Hence, what in the public announcement, what the IRP does is that he will give the names of 3 proposed authorized representatives. So 3 proposed RPs other than himself, who will be acting as authorized representatives. So when the people who are filing their claims, say when the deposit holders are filing their claims, they will select one of them to act as the authorized representative, and whoever gets the maximum votes in that sense, that person will be proposed to act as the authorized representative. So that authorized representative will now act as a representative of this class of creditors, and he will be the bridge between the COC and these class of creditors. About the claims, again, for each type of claim, there is a separate format prescribed. So for operational different, operational workmen different, operational other than workmen, other than employees, that format is different. Then for financial creditors, there's a different format. So each type of creditor will have to file their claims in the prescribed format, and within the stipulated period, which is given in the code. And once on receipt of this claim, the IRP is required to maintain a list, and he has to verify the claims, verify whether there's any security interest, and prepare the list of creditors, say a list for financial creditors, a list for operational creditors. Those lists at the end of the period of his tenure will have to be submitted to the NCLT, and based on the list of financial creditors, he is required to constitute a committee of creditors. Now, as we discuss, this committee of creditors is something like a board of directors, so they will decide what are the actions to be taken in the process afterwards, and all the major actions like about the revival, who's planned to be approved, what should be the criteria, and all those things, that all will be decided by the committee of creditors. Now, this committee of creditors is constituted by the IRP. That report is filed with the NCLT, and it will comprise only of the financial creditors, of all the financial creditors who are not related parties, irrespective of what is the stake, irrespective of whether they are secured or unsecured. So as long as on this they are on the COC, they are at par. Secured and unsecured are at par. Related parties, say like directors who have given unsecured loans, they can also have a right to file their claims, but they will not, even in spite of being a financial creditor, they will not be able to sit on the COC. So they do not have a right to represent, participate, or vote in the meetings of the committee of creditors. Even though there may be a consortium arrangement between the financial creditors, each financial creditor will be a separate part of the COC. So it's not like only the lead banker will be there. Everybody will be there. The voting share will be in proportion of the financial debts. So all these claims which are to be filed, which are to be drawn up to the insolvency commencement date. So up to that date, the amounts will be calculated, and the voting share will depend upon, will be in proportion to the amount which is due to that particular creditor on this date, on the date of insolvency commencement. Now, in certain cases, operational creditors can also be part of the COC. One is where there are no financial creditors. So suppose there's a case, does happen in very few cases, but in wherever there is somebody who's only an operational creditor, there's no financial creditor in the company, then those operational creditors will form part of the COC. Other cases is where any operational creditor may be there whose outstanding is more than 10% of the total debt of the company. Then that person will be entitled to get notices of the meetings, but again, he will not be able to sit on the COC. He does not have voting rights. So he's only entitled to get the information about what is happening in the insolvency process. So he'll be entitled to get the notices of meetings. He'll be entitled to get the minutes of the meetings, but he cannot participate in the committee. Now to the next step. So once the committee of creditors is formed and the reports have been filed with the NCLT and everything, then the first meeting of the committee of creditors needs to be held within 7 days of the constitution. Again, there are timelines which are there, which need to be adhered to. In this first meeting of the COC, the primary agenda is to appoint the RP. So either the IRP will continue as the RP or a new RP will be appointed. In case a new RP is proposed by the COC, then the voting shall take place by 66% majority, and that new RP will from then on take over the affairs of the company. Of course, NCLT approval is required in the interim. Once the NCLT order is received, then the new IRP will will take over from the IRP, and the RP will continue the process afterwards. The COC has the option to continue with the existing IRP, then only formalities will have to be done of filing the application and continuing with the process. Now, from here on, the RP will be conducting the process in the manner in which the IRP was also conducting. So now he will be in charge of the affairs. He'll be taking over from the IRP. He'll be made a signatory to the bank accounts. He will take possession of the assets and everything. Now this CRP will have to be completed within 180 days, which is the statutory time limit, with an extension of 90 days. That only one extension is permitted, that too subject to the approval of NCLT. So generally the process should be completed within 270 days. There's a Supreme Court judgment which talks about 330 days overall for the entire process, including the litigation and all that. Although practically it may not happen in this time frame practically in some of the cases. Some cases do get completed, at least the CRP gets completed within the stipulated time period. Now we saw about the valuation. So the RP, once on his appointment, the RP is required to appoint 2 registered valuers for each asset class to determine the fair and liquidation value. Now this is important because whatever plans are going to come, whatever proposals are going to come for revival of the company, they have to be in comparison with the liquidation value. So that's determining in the course of insolvency, the fair and liquidation value of the assets is mandatory. The RP will appoint 2 registered valuers for each asset class. These valuers are expected to take the physical verification of the assets of the inventory, whatever is there. They have to certify to that effect that yes, we have taken the physical verification and all that, and give their valuation reports. If their values are significantly different, there's a material difference in them, then the RP may appoint a 3rd valuer to get the realistic valuation, and the average of the 2 closest estimates in that case will be considered as the liquidation value. Now this valuation is a highly confidential document. It should not be disclosed to the COC till the time a resolution plan is received. So this valuation is always between the registered valuers and the RP. Nobody else has access to that valuation till the time a resolution plan is received or is rejected. So, until the time it is actually received. So, or the company is going into liquidation. Without that, the liquidation, so this liquidation value or the fair value cannot be disclosed to anybody. Now, generally about the transaction audit, we discussed that what the RP is required to do. So either himself by appointment of any third party professional, the RP can conduct the audit of the transactions which are prescribed. So preferential transaction where a preference may have been given to any other person. So any of these things, any of these transactions, if they have been entered into by the company, then that means that the creditors of the company have been put at a disadvantage. That money which would have been available for paying the creditors has been diverted to any of these transactions, because of which this company may have gone into insolvency. So it's one of the reasons where we try to find out why the company went into insolvency. So the RP has to conduct the audit of preferential transactions, undervalued transactions, fraudulent transactions, and extortionate credit transactions. So fraudulent, we understand. So if some fraud has been committed, amounts have been diverted to certain third parties. If some assets have been sold at undervalued price, say to related parties or to anybody else, or certain assets have been bought by the corporate debtor at a totally overpriced value. So all those cases will fall under these categories. Then extortionate credit is where the knowing that the company is in problems, the company was in need of funds. So funds have been borrowed by the company at rates which are highly exorbitant, interest rate is high, those kind of things. So all those transactions will fall into the extortionate credit transaction. There is also something which is known as a fraudulent trading and a wrongful trading, which is covered by section 66. That is also, that audit also needs to be done. So which is where when the corporate debtor or when the promoters of the corporate debtor knew now that there is no chance of helping this company, or this company is now, there's no choice but to go into insolvency. And at that time, these directors are on a higher onus to protect the assets of the company for the creditors, because the creditors have the first right on the assets of the company, not the shareholders. So it is their duty to try and protect the assets and maximize the value, at least not deteriorate the value. So during this period, they have to take extra care. If they don't take that extra care during this particular period, which is known as a twilight zone, if they don't take care of these the assets and the affairs of the company in this period, then that is termed to be of, say, a fraudulent trading or a wrongful trading, and they can be held liable for that. Again, a fraudulent trading can be a case where the company was carrying on the business, but which was to defraud the creditors, in the sense where monies have been siphoned out from the company and diverted to group companies, but the corporate debtor has been paying for the loans which have been taken by the CD. So the CD avails certain loans, that loan amount, instead of being utilized for the CD, it is diverted to other entities. So all these kinds of transactions will have to be identified by the RP and reported to the NCLT, to the IBBI, as well as to the COC. Now here, once we identify these transactions, we don't have a choice whether to report it or not. As an RP, if you have identified these transactions, you have to report them. And in case you don't find these transactions, then also you have to report that you did not come across any such transaction. So either ways, it has to be reported that whether there is a transaction or whether there is not a transaction. If there is a transaction, then along with reporting, we also need to file applications to the NCLT for taking remedial measures. So the NCLT has the power to decide these transactions, and we make prayers in the application, say if monies have been diverted to third parties, asking those third parties to bring back those monies in the corporate debtor, and so on. So depending upon the nature of transaction, depending upon the section which you are invoking for taking that action, you will be making prayers to the NCLT. And NCLT will hear those applications, although it's not a priority item. But those applications, whenever they are heard, appropriate orders and directions will be passed by the NCLT. So again, this is one of the mandatory steps which each RP needs to do in each of the transactions, in each of the assignments which they are handling. Now a little bit about the COC meetings. So the COC meetings can be held either in person or by electronic means. The RP will act as the chairperson of the meeting, although the RP doesn't have voting rights, but he will be acting as a chairperson. At least a 5-day notice has to be given to all the COC members, then to the board of directors, so directors with suspended powers, and the operational creditors on a specified class. So where there are more than 10%, so those operational creditors have a right to receive the notices. So this giving of this notice is mandatory. There's a recent judgment which has come in this week itself, which talked about whether this giving of this notice, what happens if in case there's a default in giving this notice and all. So it's an unclad judgment which says that in that particular case, the RP had missed giving the notices to these OCs who were holding more than 10%. It was held that it is a mandatory condition. There is no exception which is made, and it is a duty of the RP to issue the notices to all these people. Now the COC by its own resolution can say that we curtail this period of 5 days, but it should not be less than 48 hours generally. So that if the COC has passed such a resolution, then that advantage may be taken. But 5 days is generally something which also gives us time to prepare to the detailed agenda, to prepare the supporting documents and everything. So 5 days notice is generally reasonable in that sense. Voting items which may be there on the agenda, those voting items for that voting, again, that voting is in proportion to the outstanding financial debt. So the constitution of the COC will give the voting rights or voting percentage for each of the financial creditor on the COC, and the voting will happen in that with that percentage only. To determine whether a particular resolution has been passed or not, that voting will be considered. The quorum for these meetings is 30% or 1/3. So generally, whenever 1/3 number of members ask the RP to conduct a meeting, he will have to conduct that meeting, or the RP, as and when he feels necessary, he will call for a meeting. The first meeting of the has to be convened by the IRP within 7 days of submission of the report constituting the COC. So that that 7 days time period is mandatory. That will be in case of the first meeting. Decisions of the COC are generally by a 51% majority, but specific matters which are there, say appointment of, there's a change in RP, then approval of resolution plan, putting the company into liquidation, all those things will require a 66% majority. So kind of a special resolution what we have in the Companies Act. Otherwise, it's a simple majority. If the terms of there is this a consortium lending and all those things, but still each creditor will have a separate place on the COC. And each of those creditors, they may be a consortium or any other creditor also, they have a right to appoint some other representative to represent them on the COC. Sometimes it happens that maybe the banks, it may be a smaller bank, they are not very well conversant with the provisions of the IBC. So there, in that case, we as IPs, we can act as authorized representatives to represent the interest of this particular creditor on the COC and vote on their behalf. Where we are known as an authorized representative. So not for a class of creditors, that is different, but this is for an individual financial creditor who may ask us to represent them on the COC, and accordingly, based on their instructions, we take actions on the voting or whatever. But then that is also one of the functions which we can do as an IP, and the cost for this appointment has to be borne by that particular bank. So this cannot form part of the CRP cost. This cost has to be borne by that particular creditor. Now, we start with the resolution process as such. Till now, we had discussed the formalities of. Do you want to take a break here?
You can continue, ma'am. That's fine.
Okay. So now we come to the actual revival process. So the others were the steps which we need to take, the mandatory steps and all that in the process. Now we focus on the resolution. That is how we tried the revival of the company. So the first document in that sense is what we discussed is the information memorandum, which is the prospectus of the like a prospectus. So which gives the details of all the assets, the liabilities, the operations of the corporate debtor. The contents have been specified. What are the mandatory contents which should be there? So say the financials for the last 2 years, all those things should be given in the information memorandum. Again, the intent is that any person who wants to invest in the company, he should get a fair picture of the entity. Of course, this is not something, he cannot hold you responsible as such for the contents of the information memorandum, because a person is expected to do his own due diligence. But to the extent possible, even to attract the basic investors, we need to ensure that this information memorandum is complete with the information to the extent possible, because of course we have our limitations. We may not be getting cooperation from the directors. We may not have access to all the information. So to the extent possible, we should give everything what is available with us, and things which the potential investor will find relevant to take a decision whether he should go for even investing in this company or not. So as per section 29, this should be prepared by the RP, and it is to be circulated to each member of the COC and to the potential resolution applicant. Of course, well, before circulating to any of these, there's a confidentiality undertaking which is to be taken, and that confidentiality undertaking says there's a format. So we in which we say that that person will not misuse any information which is received which is received from the RP in terms of the information memorandum or anything under that particular in this process basically. So that confidentiality undertaking, once we receive it, then only we share it, even if it is a member of the COC. Do not share it till the time you receive this information. This is confidentiality undertaking. The form, this will form the basis for the preparation of resolution plan, obviously, because this will contain the details of the creditors, the assets, the liabilities which are there, the claims which may or may not have been filed. All those details will be covered in the information memorandum. The financial information to whatever extent is available, if the audited financials are not there, then we try and draw up the books up to the insolvency commencement date and try to give a recent picture. In some cases where I've seen that the books were not written for say last 5 or 6 years. Sometimes it may be practicable, sometimes it may not be practicable to get the books updated. Again, the COC has to agree to incur that cost of updating the books. So depending upon all those factors, try to get the maximum updated information so as to enable a third party to take make some decisions on that basis. The contents are given in the regulation, so at least those mandatory contents should be included in the information memorandum. Then once this information memorandum is circulated, and again the next step in the process is inviting the expression of interest. So inviting expression of interest is done in Form G. So the RP suggests the eligibility criteria. So here what we are dealing with is trying to find out a potential investor for the company. Now, who should be that potential investor is something which is the criteria should be fixed up by the COC. In some cases, the COC may say that we don't want any criteria. Anybody who submits a resolution plan or who submits his EOI, we are willing to consider his plan. In some cases, depending upon of course, the size of the CD is most important. What is the size of the CD? What is the level of operations and all those things? That is when the COC will fix up the eligibility criteria. What should be the basic turnover of that of the potential investor? What should be the net worth? What kind of operation should he have prior experience in either revival of companies or in dealing with the companies of this of the nature of business in which the corporate debtor is? So those criteria RP will suggest, the COC will fix them up, the COC will approve those criteria, and then we publish this Form G for inviting the expression of interest. Now again, there are timelines which are given. Those timelines will state within what period what is to be done and all those things. So the RP will make a public announcement of that Form G within 75 days. Again, it is prescribed in how many newspapers, where all it is to be done. It is also to be given on the IBBI website. Some of us miss doing that. It is mandatory to publish that on the IBBI website as well. And if the COC decides that there is some other way in which they want to disseminate that information, even that has to be done. Of course, the cost is being borne by the COC or in the course of this as a CRP expense. So we need not be worried on that front as such. So we make the publication depending upon the criteria. At least 15 days should be allowed for submission of the expression of interest, and also state whether detailed EOI is available. So what happens is the EOI is published, as in the Form G is published, and in the Form G it is written, the basic information about the company is generally given. So whether it's a going concern, not a going concern, where are the assets located, and all those basic things. Recently, the Form G has undergone a huge change. So previously it was only what we used to give was the dates. What is the next date for this? What is the last date for submission and all those things? Now that form has almost undergone a complete change. And what we are giving in that Form G now is the details of the assets of the entity, whether it is a going concern, how many employees and those things. So now in my view, it is more relevant for a potential investor to understand whether he wants to ask for a detailed EOI or not. Earlier, we just used to give the statutory dates which were there, which was in that sense not relevant for an investor. But the new format is that sense more relevant. So once a person sees that Form G which is issued in the papers, that person will contact the RP and ask for the detailed expression of interest. So the detailed criteria will be given in the detailed expression of interest. So he will, and along with the supporting documents. So he will have to give the supporting documents, which list is given in the detailed EOI. Say the financials to prove his net worth, the financials to prove his turnover, or any other supporting documents which have been asked by the COC. to enable the RP to shortlist him, to check whether he's meeting the criteria or not. Again, another document is of course the confidentiality undertaking, and the fact that he's saying that he is eligible to act as a potential applicant, resolution applicant, based on the criteria which are given by the COC, as well as under section 29A of the code. So these things he will specify. Of course, we are aware of 29A. Those 29A need not be reproduced in the detailed expression of interest. We give a reference to that, but he needs to commit that yes, I am compliant with all those conditions. Generally, along with the expression of interest, in smaller cases, no deposit or fees are expected. Fees cannot be levied in any case, but a non-refundable deposit also cannot be taken. In bigger cases, sometimes they do take a refundable deposit, so that to show your seriousness generally, and for when the RP is dealing with such a huge case, in those cases sometimes they do ask for a refundable deposit to be submitted along with the expression of interest. Now, once the expression of interest is published, and the person asks you for those detailed expression of interest, you will give him the document which contains the detailed criteria of what all of what is expected by the COC, say business capacity, the financial capacity, whatever those criteria may be. He will submit the section 29A declaration. He will submit the other documents which are there as a supporting in his claim that he is eligible to be a resolution applicant. And all those documents will be submitted within those 15 days. Now, at the end of those 15 days, if the COC feels that, say, nobody has come up with the expression of interest, or if maybe whatever is received is not satisfactory, then one modification is allowed. So they can change the criteria only once. So the maximum one modification is allowed. And again, the entire process which was done in the initial expression of interest will have to be done. So again, publication of that in the newspapers and all that, and again given 15 days time. But that earlier there was no time limit. In the recent amendments, they have brought in this time limit. So only one modification will be allowed. So this was about the criteria. Again, this is totally at COC discretion. The law does not specify what should the criteria be. Sometimes the COC, depending upon what is the status of the CD, they may say that we don't want to give any criteria. Anybody who comes with the plan, we are welcome, or we are going to look into those plans. So if that is the case, then you say that there is no criteria which are decided. Now, once the expression of interest is submitted to the RP will examine that. He will verify that the applicants are in fact eligible as per the criteria which is stipulated by the COC, as well as they are compliant with section 29A. And we cannot simply go by the declaration in 29A. We have to do our own due diligence, do a desktop search. If you feel that the case is very complicated and there is bound to be certain litigation which is going to happen, appoint a third-party agency. Those third-party agencies will do a very, very thorough search on the 29A applicability of a particular resolution applicant, but we will get all that information. Then there are certain websites also which are there, which help you to find out on your own. So I came across, I'm not advertising this website or anything, but it was really handy, and we as RPs, we should look at these kind of resources to ensure that we have done our job properly. There is something called a probe 24 or probe 42 something, so which will give you all the details about any entity. You write the name of that entity, and it will give you all the details right from the balance sheets which may have been filed with the ROC, everything. So instead of taking only a ROC search, go to this type of websites. They also give you the list of cases filed by and against the company. Now, I have not seen in public domain this information being available anywhere is that easily. I just write the name of the company in this particular site. Of course, it's a paid site. So for each company, you need to pay some very small basic amount, 300 or 500 rupees. But it is worth that amount because you immediately get whatever data you get on the ROC website, you get that in the first instance. And not only get the documents, you get it analyzed. So they have made their own charts of how the progress of the companies, what is the business which has been carried in, say, in the last 3 years or last 5 years, whether there's a deterioration, whatever it may be, of the resolution applicants, I'm saying. And whether these directors are, whether they are directors in any other companies, whether any cases are filed by this company against somebody else, whether any cases are filed against this company. So whatever information you generally need to do a 29A check, you will generally find all that in one place. At least 80% of it you will find at that one place. It's really handy. You can give it a try. And of course, there are other third-party agencies, say like Signalex or somebody else. So I have used Signalex in a couple of cases where they gave a very detailed search of the 29A. So there it was very litigious process, CRP, and I had to be really sure about whether this person is eligible to be a 29A, under 29A or not. So we appointed that agency. We got a detailed report from them, and which gave out all this information about any cases which are pending in any courts, then companies in which they are directors, any other kind of no, whatever 29A needs us to do, all those. So wherever required, feel free to take the support, because ultimately it is our responsibility to identify whether a particular person is eligible under 29A or not. Although we may not declare somebody as ineligible, we need to place that. There's a Supreme Court judgment which says that we cannot disqualify somebody as RPs. We need to place that information before the COC, saying that this person does not qualify 29A. So then after that, it is a COC's prerogative to take a decision whether to disqualify that person or not. We are only supposed to report that to the COC. Basis that judgment. So we need to do our job in that sense, find out whether this meeting the criteria and all that is, technical, which we can easily find out. But 29A check is something which is really deep, going into the connected persons, going into the other persons who are connected or acting in concert, and those definitions in 29A. It's very wide. So instead of missing out something, if you feel that there's going to be some complications in this case which may arise, better to get a third-party certification to your check. So the agencies are available. I think it is it's really helpful. At least in my experience, I found it is very helpful. If the corporate debtor is a MSME, however, then we know that at 29A, C and H, only those two clauses will not apply. All other clauses of 29A do apply. So even if it's a 29A situation, if it's a MSME situation, even though C and H, even if they're exempt from C and H, you need to check the other criteria which may be there. If there is a person who is going to be supporting this CD, as in the MSME promoters to file their plan, we need to go and check whether even that person is also eligible. And if he's a connected person, then whether he fits into 29A or not. So just because it's a MSME 29A, only two clauses are exempted. Everything else we need to check. So again, similar declarations, everything will come from them also. Then the RP will prepare the list of the potential applicants. Now we know about the provisional list and the final list. So provisional list we circulate within the stipulated time. Then if anybody has objections, they have to raise those objections within 5 days. We have to examine those objections and decide now whether to include or exclude depending upon the objection. And then the final list has to be issued within 10 days. Now the IM, the evaluation matrix, and the RFRP will have to be issued to all those people whose name was there in the provisional list. So even though that person may not go to the final list, still if his name was there in the provisional list, we need to circulate these documents. We have already taken the non-disclosure from them. So these documents have to be circulated to all of these people. Now we go to the RFRP. So in this process now, till now, we have received the expression of, we issued the Form G, we received expression of interest from certain people. We have now prepared the list of potential resolution applicants and the final list of applicants also. Now we are circulating the RFRP. So to the list, to the people who are who are in the provisional list. Now RFRP is a document, so request for resolution plan. This document is something which will give the detailed steps of the process, the manner and the purpose of interaction with the RP and the relevant timelines. So RFRP generally, if you see, it's a very long document and it has a lot of legalese which is there. So which talks about the exemptions to the COC, exemptions to the RP, the extent of liability and responsibility of the RP and the COC. Statements such as whatever due diligence is to be done by these entities independently. The RP and the COC is not responsible for whatever information is given. The parties are expected to do their own diligence. The RP is not required to go out of the way to help certain resolution applicant, he is supposed to make his own, only the visits needs to be arranged by the RP. Beyond that, he is not required to go out of the way to do something in respect of a particular resolution applicant. So all those statements, the extent of liability, responsibility and everything is given in the RFRP. It also talks about in what manner the plan is to be submitted and what is it that the COC is expecting in the plan. As in whether the what are the timelines which are going to be there when the plan is to be submitted. Then 30 days is the minimum which needs to be given. Then what is the upfront payment, not in terms of money, but in terms of saying where what is the COC expecting out of a particular plan, say whether a maximum upfront payment, what is the weightage which is going to be given in those cases. And these kind of details are going to be given in the RFRP. So the RFRP need not contain actually the data about the CD as such. The RFRP contains the data about what is it that the COC is expecting in a particular resolution plan. So it doesn't say that we need say so much amount, but it will just say in what manner the plan is to be submitted, what is it that is going to have a preference, what is it that the COC is looking for. It will also talk about the non-refundable deposit, the refundable deposit or the performance security which is to be paid. Now the performance security is mandatory. Earlier it was not there, but the performance security is now become mandatory. What is the timeline within which that performance security needs to be submitted, from which bank it needs to be taken, in whose favor it needs to be given. So all those things will be included in the RFRP document. Again, the modification of RFRP can be done only once. If it is modified, it will be deemed to be a fresh issue, and again those 30 days will have to be given. Now with the recent amendment which has come in October 2022, although not very recent, but it's still new in that sense. Now that RFRP can be issued only with respect of one asset of the company. So suppose the first RFRP is issued for getting a resolution plan for the company. The no satisfactory plans are received. If the COC decides to go for a fresh RFRP, in that instance, the RFRP can be issued only for one of the assets of the corporate debtor. Now, that technically, yes, it may be applicable in certain cases, but I have my doubts about how it will work practically. Because here you will be, if there is more than one asset, so there is a land and building and a plant and machinery, and you get bids or you get resolution plans for the land and building, but you don't get anything for the plant and machinery. How do you deal with that practically? So the plan will only deal with the land and machinery, but you may not get a plan for the plant and machinery. You will get it only for the land and building. You may be able to dispose of the land and building, but then the question will, again, practically what we need to maybe think on this is who deals with the CRP cost? What is the proportion between the two which is to be dealt with? If there are two plans which are received, who bears what proportion of the resolution cost? Then in terms of making payments to the CD. So practical challenges might arise in that case, although I personally have not experienced RFRP only for one asset, but it will be very interesting to see how it actually pans out in the practical scenario. But technically, by law, you will be able to issue a RFRP only for one asset of the CD in the second instance, not of course in the first instance, but in the second instance, if you fail to receive any plans, satisfactory plans in the first instance. So that provision has now been made in the regulations have been amended. The timeline for submission of the plan can be extended with COC approval. We cannot take that decision. That can be extended only with the COC approval. Now, just a couple of slides before we take a 5-10 minute break is about the evaluation matrix. First, what we need to remember is that the evaluation matrix comes into play only if there is more than one plan which is likely to be received. In case there is only one expression of interest, the evaluation matrix is not relevant because the evaluation matrix compares two plans. So evaluation matrix talks about if there is more than one plan which is received, how is the COC going to decide which is a better plan? So only going by the maximum amount which is being paid is not the only criteria. So the evaluation matrix will give the other parameters which are there. Suppose there are two plans, who gives the maximum upfront payment, who has the shortest time of the plan, the execution time of the plan. Somebody may have a 40 crore plan, but who's giving that within say 10 years. Somebody may give a 30 crore plan, but who's willing to make payment in 6 months. So the COC will decide the weightage. Of course, bird in hand is what two in the bush. So they may have a parameter which says that shortest time period of the plan will have more weightage. So evaluation matrix is a document which will give that weightage, so that a potential investor, when he's submitting a plan, he knows on what lines the plan has to be made. So whether he should make maximum upfront payment, whether he should have the shortest tenure of the plan, to maximize the weightage of, when the two plans are being compared, what is it that is going to have the maximum weightage. So that evaluation matrix also has to be circulated with the RFRP. If that evaluation matrix is modified for certain reason, that would be only one modification is allowed in the first place, and again that will amount to a reissue. So again those 30-day period will have to be given. Now, even though the evaluation matrix, somebody's plan may be better in terms of the evaluation matrix, still the COC has a right to reject that offer and go with some other plan. So that is also made clear in the RFRP document. So the COC has the right of rejecting any resolution plan or all the resolution plans, even if they feel that those plans are not satisfactory. So all those conditions will go in the legalese in the RFRP. But again, that evaluation matrix will be helpful only if there is more than one plan which is to be considered by the RP and the COC. Now, something in respect of the data room. So this concept you would definitely have heard about the data room. So data room is any place where which is used to house data, so to store the data. So now the data room can be physical or it can be virtual also. Generally, it's a virtual data room in these cases where the information memorandum, if there are a lot of documents which are there, then the RP will store that in a say in a Google Drive or some other data room or something, and where access will be given to the potential applicants who can access data from there. So whenever there is some new document which comes, now whenever there is a modification to the IM, we will make modifications in that data room and inform everybody that such and such document has been uploaded or new documents have been stored there, which those people can go and access. So because IM is a dynamic document, you would all agree that as and when we keep on getting information, we keep on adding that to the IM. So whatever that information, instead of, if there are large number of potential applicants who are there, if it's a bigger company and a lot of data is there, then this virtual data room is always helpful. For smaller cases, maybe where there are only one or two applicants and not a lot of information, we can share that on email also. But it is handy to have a data room where all the information is stored in one place. As I mentioned, any iCloud Drive, OneDrive, Google Drive, or these are generally used for smaller things. Otherwise, we have specialized agencies also who provide these services as a service. So we can avail paid services from such data rooms also for larger cases. Maybe. So now the next is moving to the resolution plan, but I want to take a 10-minute break here if okay with you, and we'll all will reassemble at 11:20. Is that fine?
Sure. Ma'am, voice is not.
I think she's taking a break, small break. 11:20. She's going to be back.
Should we start?
Sure.
Yes, please, ma'am.
Yeah, thank you. So now coming to the resolution plan. Okay. So as we know, resolution plan is covered in section 30. The contents of what should go in a resolution plan is covered in section 30. Resolution plan is given by a potential investor as in a resolution applicant who's going to who wants to take over the company for its revival, and he is going to give the details of what all is his plan to revive the company. So again, the intent is that keeping with the basics of the code, the plan should be for resolution of the corporate data, how the corporate data is going to start working again, or if it is already working, then how it is going to improve its operations or build upon those. So generally what will be given in a resolution plan is, of course, the basis will be the information memorandum document, so which will contain the list of debtors, creditors, and everything. What he needs to give in the resolution plan is basically what, according to him, is the reason for this company going into insolvency, and how is he going to address that reason? Because it should not be a situation where, again, in spite of this resolution and on this entire process, the company again faces hurdles later on, if this person is not able to implement the plan properly because he's not understood the root causes. Or he will say what are his plans with the company, whether he wants to diversify, whether he wants to add something to the capex, he wants to put in more money for the working capital, whatever it may be. So what all are his plans is to be given in the resolution plan. So resolution plan, the code does not specify what all should it cover. In the sense, it doesn't say that so much money needs to be given, so much amount needs to be paid in such and such time. So all that has been left to the market forces. Let the negotiations and the commercial negotiations between the COC and the resolution applicant take care of that. The only thing what the law says is that it should deal with how is the company going to run afterwards. The minimum amount which is to be paid under a resolution plan should be more than the liquidation value of the CD. Otherwise, there is no point, because then in liquidation, that is the amount which it is going to fetch in any case. So the resolution plan should give something over and above the liquidation value. Although the liquidation value is not disclosed, but then the resolution applicant is expected to make his own calculations and ensure that the amount which he is submitting in the plan is more than the liquidation value of the CD. Then it should say that the 100% of the CRP cost, the resolution process costs which have been incurred, are going to be reimbursed by the resolution applicant. So there is no option there. 100% cost has to be reimbursed. So if the plan amount is of X value, this CRP cost will always be at actual, so X plus whatever that amount is. Now, again, he needs to specify how he's going to distribute that amount between the financial creditors and the operational creditors. Amongst the financial creditors, also the differentiation, if any, between the secured, unsecured, the priority of payment. Then in case of operational creditors, how is he going to deal with the workmen? How is he going to deal with the employees, with the other operational creditors? It doesn't say how much is to be paid, but at least it says that in case the company went into liquidation, what is the amount which the operational creditors would have got? So at least that much amount needs to be paid to the operational creditors. So the amount again is not specified because it's a dynamic number. Each case will have a different number. So it's only thing is that in case under the waterfall, whatever amounts these people should have got, they would have to get something more than that in the course of this resolution plan. So which means basically that in case of a liquidation, whatever amounts are given, so the plan value should be more than the liquidation value of the corporate debtor. Then the plan should also provide for how the company is going to be run, who are going to be the directors of the company. If it's the MSME itself which is again submitting the plan, then how it is going to revive and what is the change which is going to happen. Then how is the plan going to be implemented? Say the amounts are going to be paid within how much time. Again, the law does not specify within how much time. It is up to the resolution applicant and the discussions, negotiations. Within how much time the amount is going to be paid to the corporate debtor, how much amount is going to be put into the corporate debtor, how much amount is going to be paid to the creditors, to the financial creditors. Then at what stage the charge against the company's assets is going to be withdrawn. So in the plan, all these things should be given in detail. So the plan should be workable, as in implementable in that sense, as to how these things are going to be implemented. So somebody, at what stage the charge value or the charge should be withdrawn. So unless these things are given, the NCLT order will not be complete as such. And when we as resolution professionals, when we are dealing with such plans, then when we are giving that Form H also, we need to have all these details readily available as to how these things are going to happen, how much money is being paid to the PF. Now, as we know, PF, so we need to pay the entire amount of the dues which are there. So not maybe the damages and the penalty, but the amount which is payable as interest and the amount unpaid or deducted but not paid, that has to be paid as a priority for PF. But the other amounts which are there, that can be dealt with as per section 53. And the amount the resolution applicant has the discretion how much amount he wants to pay. Then the plan should also deal with what is going to happen to the existing cases by and against the company. So what is going to be the fate of those cases, whether these cases will be, whether the applicant proposes to pursue those cases or he wants to withdraw those cases withdrawn. So whatever is it that the resolution applicant wants, all those things he has to state in the plan. And because of the binding nature of the resolution plan, because of the order which comes from the NCLT in this regard, no separate actions need to be taken. So even now, even if we say that the plan is by way of a scheme of arrangement or a scheme of amalgamation, then that can also be included in this particular resolution plan. And under section 230, so NCLT will approve, NCLT's approval to this plan will mean an approval under section 230 of the Companies Act. So all those things, whatever it is that the resolution applicant has in mind with respect to this corporate debtor, that he can include in the plan. Any waivers which he wants from paying certain expenses, say the electricity dues or some claims which have not been received by the RP, but which are there in the books of the company, or some liabilities which are not there at all, no claim is received, it's not there in the books. So how is he going to deal with that? So just a line which says that all those will be extinguished, that is sufficient, but each of these aspects must be dealt with in the resolution plan. So the resolution plan is kind of a complete document in which whatever under the sun the resolution applicant, of course, which fits into section 30 and the regulations, whatever he wants to ask from the NCLT, he can ask from the NCLT. So maybe gross things like where some other entity is or some other government department is involved, that may not come under the domain of NCLT, but otherwise everything else will be granted by the NCLT, including where certain licenses, if they're expiring, and the resolution applicant in the course of implementation of the plan asks for an extension in the resolution plan, that extension for 1 year is also possible. So when we are drafting a resolution plan, suppose we have an assignment of drafting of resolution plan only, then we need to keep in mind all these things as to what is it that we can ask. We ask maximum whatever you can in that resolution plan, so that the NCLT will be able to grant whatever is there in their domain. Of course, they will be able to ask grant all those things. So something need not be missed out, like some cases which are there, then some known unknown liabilities. If you want to extinguish something, starting on a clean slate in that sense, then of course you have the immunity under 32A. If it's there's a change in management, there's going to be an immunity which you're going to get from any past liabilities of the company or any past actions which the company may have taken. So make sure that all those, even though it is there by law, make sure that you highlight it in the resolution plan that since there's going to be a change in management, 32A benefit should be passed on to the resolution applicant. And when we are on the other side of the table as a resolution professional, when we are checking a resolution plan which is submitted to us, then we need to go into all these things, ensure that the plan is compliant with all these requirements about how somebody might want a reduction of capital without undergoing the process of section 66 or anything which they need. So the entire old capital may be wiped out, the paid up capital and new capital may be introduced by the resolution applicant, or a transfer of shares, change in directors, whatever it may be, everything under the sun you can ask in the plan. And again, which shows the workability of the plan. So you have thought about everything when you're drafting a plan, and a resolution applicant knows what he's doing here. So it becomes easier for us also as RPs to deal with such plans, so which are covering everything. Typically, the actions or things which may not be covered is in respect of treatment of personal guarantors, especially if it's a third party which is giving a plan. Then the dealing with the personal guarantors or the assets of the personal guarantors cannot be covered in the resolution plan. So when we as RP are checking the plan, we need to, once the plan is submitted to us, we need to find out whether there are any such clauses which are in violation of section 30 or which cannot be allowed under section 30. We need to highlight them and we need to ask for the plan to be modified or those changes to be made before we can say that this plan is compliant with the requirements of section 30. Other things which need to be as a mandatory contents which need to go in are the specifically the sources of funds from where this money is going to come to pay this pay under this plan. So generally making statements like say from friends and relatives, from friends and associates, that is not going to help. Specific sources need to be identified from where these funds are going to come, from where this resolution applicant is going to generate those funds. If there is a third party who is going to come in and put that money in the company, or if the resolution applicant is going to borrow funds, then at least a comfort letter, if not a sanction letter, so that the COC is able to take an informed decision that yes, this person does have the wherewithal or the credit worthiness or the sanction from certain financial institution to actually pay this money if their plan is approved. So typically the COC is going to have these doubts, especially in case of MSME, where it's the same promoters who are going to submit the plan and join that exemption. So in that case, then having this source of funds from where they're going to put that money in is very, very critical. So even we as RPs, when we are examining such a plan, we should ensure that the source is properly disclosed. Just saying that we will borrow from friends or something, that is not going to help. They could have borrowed that earlier and saved the company from insolvency. Even if it's a third party, then also that sources of funds has to be given very clearly. In most of the cases, what we do is we ask for that comfort letter or we ask for the sanction letter in support of the claim that this person is going to invest so much money. So make sure that all those sources are properly identified. Then what is the liquidation, whether we discuss that whether the liquidation value is being met in respect of payments to operational creditors or to the dissenting financial creditors. Now, dissenting financial creditors are those who are going to vote against the plan. So when the plan is being submitted, we don't know who's going to vote against the plan. But then the plan should deal with the eventuality that if somebody votes against the plan, then he will be paid upfront or in priority to the other creditors. So those statements and everything should be there. The term of the plan has to be clearly defined, as in within how much money, within how much time, what money is going to be paid. And again, there's a bifurcation of how much money is going to be paid to the creditors, when it is going to be paid, and to be introduced in the company. So the all this amount is going to form the plan value. So say a certain applicant will pay X amount to the creditors, Y amount to the financial creditors and other expenses, and then he may put in some other amount in the company, which will be towards the working capital, which will be towards the capex required. So that amount is also to be computed together as the plan value, that entire plan amount. So even though that amount may not being paid to the creditors, but it is being introduced in the company towards either the capital or towards the whatever working needs are there of the CD. So this entire amount will be used as comparison, but then the implementation of that amount, how are they going to put in that money, or how are they going to, when are they going to put in that money, what would be the timelines and all that should be there given in the resolution plan. Then the management and control of the business, who's going to sit in the management, who's going to take the decisions. If they want to borrow from somebody, then what is the how are they going to repay that money from the operations of the CD or from their own sources. We also usually will ask for the 5-year projection, or if they have given a projection as to how this company is going to run, then ask for the basis of that projection as RPs, or even when we are drafting the resolution plan, because those numbers should be justifiable. And the members of the COC are intelligent, they know how these things work. So we generally cannot just write some numbers and hope that they get passed. Those we need to have proper backup. Say suppose it's an entity which will say suppose it's a hospital industry. So in that industry specifically, you will have to, when you're preparing the plan or even examining the plan, you will have to see that what are the assumptions what they have made. Say right now it says 50 beds are being occupied. Are they assuming that over the next 5 years it will go on to 150? So what is the increment? Is that realistic? And then are the numbers in proportion to what is the increase that they are projecting? And towards that increase, what is it that they're proposing to change? As in, if they want to move that hospital from a 50 bedded to a 100 bedded, what are the relevant or necessary capital expenditure which they are going to make? Is that also covered in the plan? So that plan actually has to be realistic. It should be a workable, practicable plan to the extent what we can see as a resolution professional when we are examining that. We should utilize all these kinds of tests in that sense to determine whether this is a workable plan or not. Ultimately, the decision is going to be with the COC, but the COC is going to ask us to give all these inputs. So we should be ready with our examination, ready with asking questions to the resolution applicant that give me the 5-year projection, give me the basis for the projection. On what basis are you saying this? In what time? The cash flow statement generally. And they have generally they will, if a resolution applicant is serious about a particular plan, he will have all these details very readily available. So we should ask for those when we are examining, and when we are preparing a resolution plan for somebody, then we should also have all these things available, so that tomorrow if we are asked to justify, we should be able to justify why such and such things are included in the plan. Because again, this resolution plan is going to be binding on everybody. The NCLT is going to approve that plan basis your certificate. So we are certifying that Form H. So it's a huge responsibility when we are certifying that Form H, saying each and every aspect of the code has been dealt with. Each and every provision in the resolution plan is in compliance with the requirements of this law and any other law which may be applicable. So there, it is a huge responsibility for us to sign Form H. So we need to do our homework. We need to do our due diligence properly in that case. Now the plan, once it is received from the resolution applicant, we need to examine each of those plans and we need to place all the plans before the COC. So we cannot say that this is the best plan, so I'm placing only this. All the plans have to be placed before the COC. All the plans will be voted upon, and then the one which gets the maximum votes, that will be declared as the successful resolution plan. But we cannot hold back any plan. It is our duty to place all the resolution plans in front of the COC. Now, the resolution process cost, as we have seen the definition. So generally all expenses which have been incurred for the resolution process, including the supplies of essential goods and services, then the amount, of course, the amounts have to be ratified by the COC or fixed by the COC. Only those, then the valuation expenses, all those which are incurred in the course of CIRP, all those will be taken as the resolution process cost. And in the resolution plan, 100% of that resolution process cost should be reimbursed to the CD, as into the COC.
Ma'am, one question here.
Yes, sir.
Basically, on the management, when you said, what is there any condition that in a resolution applicant, the new applicant who's coming, how many years he should continue as an? I mean, can he sell his ownership say within 6 months? मैंने आज लिया 6 महीने में मेरा share बेच दिया. Are you understanding my question?
Yeah. So that will depend upon what is written in the RFRP. So RFRP, the COC makes a condition that the new management should continue for, say there is a lock-in, then that will have to be adhered to, otherwise no.
Okay, so then in that case, he can even, like if I buy today and within 6 months I can quit. That's the way.
Yeah.
There is
Although,
no condition in RFRP.
there's no condition. Yeah. If there's no condition in the RFRP, technically yes, you can, that person can move out.
Okay, thank you.
So now we come to the resolution plan submitted and now the success or failure of the plan. So a resolution plan approved by, once the resolution plan is placed before the COC will vote upon it. The plan which gets the highest vote will be the successful plan. And that plan will then be placed before the NCLT for approval, along with the Form H which is certified by us and which says that everything is compliant. If the NCLT approves that plan, then that plan has a binding value on all the debtors, employees, members, creditors, guarantors, and any other stakeholder. So tomorrow, if some creditor has failed to file his claim, he cannot at a later stage come in and say that I was not considered. So it is binding on everybody. Whatever is stated in the plan is the ultimate statement. So tomorrow so in that sense, a resolution applicant now gets the company on a clean slate. Of course, the tax angle, the carry forward loss and all those things have to be seen. But then that is the part of the due diligence which is done before a plan is submitted. So all those things happen beforehand. So once the plan is approved by the NCLT, then it will be implemented as it is stated in the implementation schedule given in the plan. Then if the NCLT does not approve the plan for whatever reasons, then the plan is said to be rejected and the liquidation will commence immediately. So automatically it will go into liquidation. And once the plan is approved, then the moratorium will cease from that date. So we saw in the moratorium section that the moratorium, as soon as the plan is approved or any of the other conditions happen, then the moratorium will cease from that date. Now, if the plan is not successful, or if suppose no plan is received during that 180-day period, no plan is received by the COC or the NCLT, or if the NCLT receives a plan but that plan is rejected for any reason, then the company will go, the automatic logical conclusion is the liquidation of the entity. Or if the COC, for reasons to be recorded in writing, takes a decision to liquidate the corporate debtor at any time during the CRP period. So suppose there's a company which is closed, say for 5-10 years, if nothing was happening, the company is closed down, there is nothing, not much, there may be assets, but there is no chance of revival of the company. Then the COC may, in its commercial wisdom, take a call that there is no need to run this company or even run this process as such. So they may take a decision to have for an early liquidation, pass a resolution with a 66% majority and file an application to the NCLT saying there is no process to run as such because nothing is going to happen here. There are no employees, there are no assets or whatever the case may be, and there is no chance of revival. So there's this section, this regulation 40D or something which is there in the CIP regulations where you need to give the reasons if there's an early liquidation which is being proposed, or at any time when the liquidation is being considered by the COC. Those clauses have to be complied as in you have to make a note in the minutes that the COC has considered all these aspects and then only they have gone for liquidation of the corporate debtor. So ensure that those are included in your minutes. Another case where the liquidation, yeah.
Yeah, ma'am, if the plan is rejected by the NCLT and we have sufficient time, I mean, 1 day is not expired, can we have this second time plan? No. It's only one time.
If there's a time which is available, then the COC can say that we are going for this process again. If time
we
is
can go now.
Yeah.
Okay.
Yeah.
Thank you.
Then one more case where the liquidation can happen is where the plan is approved, implementation has started, but then there is a contravention. In that case also the company will go automatically into liquidation. So of course automatically as in there's an NCLT approval which will be required, but then the only recourse is liquidation in that case. Now, in case of liquidation, generally assuming that is a liquidation under section 33(2), where the COC is passing a resolution for commence putting the company into liquidation, then or in case of a liquidation, the resolution will be by 66% majority. The RP will have to give his consent to act as a liquidator. At each stage, our consent is to be given. Unless we don't give the consent, or unless the COC passes a resolution to change the RP and not appoint him as the liquidator. In that case, only the liquidator will change. Or in case where the NCLT has passed an order where the resolution plan was submitted to the NCLT, saying that it is compliant, but when the NCLT looked into it, it was found out that the plan was not in compliance with section 30, and accordingly the resolution plan was rejected. So then that is why I'm saying that form H, the compliance certificate which we give, has tremendous responsibility. In case a resolution plan is found to be non-compliant with section 30 and we have given our certificate, that means that matter is going to be referred to IBBI and IBBI is going to ask for the replacement. And of course, we know what the actions which can follow against the IP. But again, which shows that the NCLT is going to say that this person cannot continue to act as the liquidator in that particular case. So whenever we are dealing with resolution plans and whenever we are giving that form H, we have to be really, really careful as to what we are writing in that, and whether we have actually checked everything that the plan, and we have made an independent inquiry. We shouldn't be saying that we have relied on somebody else or somebody else's assessment. We have to make our own assessments about the compliance with the requirements of section 30. So that is very critical. One more thing which I forgot to mention in the plan is the plan should also deal with the PUFE cases. If certain PUFE transactions were identified by the RP and the applications were filed, or the applications are in the process of filing, or if the audit is in process. Sometimes we are not able to adhere to those timelines which are given, and not sometimes, many a times we are not able to adhere to those timelines for PUFEs. But if that audit is in process and it is not concluded that there are no such transactions, then the resolution plan will have to deal with the situation that in case an application is filed with the NCLT, how is that application going to be dealt with? So either the resolution applicant will say that I will pursue those cases, and in that case, whatever funds are recovered from those applications will come to me. Or he can say that I am not concerned with these PUFE cases, let the COC deal with them, the COC will pursue, the RP will pursue, and whatever amounts, if any, realized from those cases, they will go to the COC in the proportion which the COC decides. So the resolution plan has to clearly specify what is going to happen to the PUFE applications. Now a quick look at the waterfall arrangement. So we know in the liquidation process, now I need not elaborate much. Again, in the liquidation process, the order will come, then that will be the order date, will be the liquidation commencement date. So mind you, there could be a gap between when the COC passes the resolution for liquidation and actually getting the liquidation order. It could take months in between. So now there are regulations about how much fee we can charge during that period and all that. So we have to be very careful about either overcharging or undercharging during that period. So the amended regulations are there, which we need to be very careful about. Then once the liquidation regulation, the order is passed, the liquidation, that will be the liquidation commencement date. Again, we need to make the public announcement within 5 days, invite the claims. Here we get 30 days to filing the claims. New amended regulations, please read the October 22 regulations. A lot of changes have come in the CRP as well as in the liquidation regulations. So where in case earlier we were not required to take cognizance of the claims which we had got in the CRP process, everybody was required to file new claims in the liquidation process. But now with this new amendment, even we need to take cognizance of those claims also. So if a creditor who has filed a claim in the CRP fails to file a claim in the liquidation, we still have to take that previous claim into consideration. So a lot of changes are there between what we used to do earlier and now what we need to do. So just make sure that you read the regulations properly. One more change which is come in the CRP, and which is noteworthy, is that we need to have a separate email ID for each case. Previously, we were asked to use only our own ID, which is registered with IBBI. But there is this process email which is now to be maintained for each assignment. So in case there is a change from IRP to RP or RP to liquidator, we just hand over that mail ID to the new incumbent. So we need to have a separate mail ID. From that mail ID, previously only the public announcement was sufficient for us. Now we need to intimate the creditors of whose details are available. We need to inform those creditors that this company has gone into insolvency and please file your claims. So this is a huge change which has come in, and which can be held against us if we don't communicate with some creditor or inform some creditor that this has such and such thing has happened. So be very careful that that intimation should go from the new mail ID, and we should be sending that intimation. Generally, it may be simpler in case of financial creditors. We might get the information from the ROC website, looking at the charge certificates and the forms which are filed there. But for other creditors, it's going to be difficult. So even the departments we have to intimate that this company has gone into insolvency and please file your claim. So that is now an onus on us, so which we need to take note and we need to act accordingly. Coming to section 53 in the liquidation process. So section 53, as we know, is the priority and the manner in which the funds which are there in the liquidation estate have to be distributed. Now, again, coming to liquidation estate section 36, please ensure what all assets are you putting in the liquidation estates. There are certain things which cannot be included, say like the assets of the subsidiary company or assets which do not belong to the CD, the gratuity fund, the provident fund. Those things are not going to be included in the liquidation estate. So make sure that your liquidation estate is properly constituted, and then only you will be able to distribute. Again, there are timelines on within how much time you need to distribute from the date of realization in the liquidation regulations, that we need to be very careful about. Maintaining of books of accounts, filing of our progress reports or whatever other preliminary reports and other reports within time. Again, that is important. Asset memorandum provisions have undergone a change. about submission and those things. So those provisions also we need to be cognizant of. Then, of course, the claim verification, all those things are as it is, what we need to do while admitting the claims. Stakeholders consultation committee has undergone a change. What was there from 2021 to now. So that stakeholder CC composition has undergone a change. It is virtually a COC now, which is in a different name. And again, the voting and those things are going to be happening there also. So all those things we need to make sure that we are complying with those provisions. So the stakeholders consultation, the minutes, and all those things we have to take note of. Then the meeting of the SCC needs to be held. Now there's a time-bound manner in which the meetings need to be held. Earlier, those regulations are not there. So we have to update ourselves on those grounds, on those fronts also. Then coming to the, yeah.
Ma'am, can I ask one question?
Yes, please.
Ma'am, as per section 53 of IBC, we have to consider the priority. As per the first priority, it is liquidation cost, and second priority, the workman and secured creditor at pari passu class. So 24 months from the date of liquidation. So
before
now,
the date of liquidation. 21 months before the date of liquidation.
Before the date of liquidation. So now the claim received during CARP, it is much before this 24 months. It's prior to these 24 months. So the same claim has been updated and given. So should we consider the claim received during CARP?
We can consider that if there is a way in which, see, if it could be a workman claim you're talking about, or a second creditor claim.
Yes.
If it's a workman claim,
it is a workman claim as per the priority 24 months prior to the liquidation dates we have to consider. But we have admitted their claim during CARP as well, which is prior, beyond the cutoff date given. So now we cannot refuse their claim since it is not covered in this. So should we admit their claim or not?
Here what you will do is only the 24 months. If any claim is falling within the 24 months, that will come in the priority claim. Everything else will go in the operational creditor claim.
Okay, it will be considered. It will not be rejected. It will be considered as other claims.
It will not be a priority. So anything beyond 24 months will be an OC claim.
Yes.
And 24 months will be only priority claim.
Clear. Thank you, ma'am.
So coming to the waterfall, now we will each of these criteria which are there. So if there's any insolvency process cost which is remaining unpaid, then those will have a priority. So this distribution is out of the realized asset. So you sell some asset, what is there as a liquidator with you, and out of the realization which you receive, how are you going to distribute that money? So this is what section 53 talks about. So first, that money will be utilized towards payment of the insolvency process cost which is unpaid, and the liquidation cost in full. So the liquidation cost will mean the liquidator's fees, anything else which is going to be required towards the liquidation cost, say some audit fees or some professional fees or anything which again, if a valuation is required, then the valuer's fees, all those will go in the liquidation costs. So those have to be met in full. If something is left out, then we move to the second category. Now, second category is, there are two kinds of creditors in this. One is the workmen and one is the secured creditors. And these both will rank equally. So if you have 100 rupees will be distributed between workmen and the secured creditors in their inter se proportion. If after distributing that, if something is left, then we move on to the third category, which is wages and which is salaries basically for employees. So that's why again, the distinction between secured creditors and unsecured creditors becomes relevant here. The distinction between workmen and employees becomes relevant. Again, workmen's dues for 24 months and beyond 24 months, employee dues for 12 months and beyond 12 months. So all those things, when we are accepting the claim, we have to identify amounts for each of these categories, because that is how the distribution is going to happen. Then if any amount, so it's a waterfall. First category is paid off completely, then you move on to the second. Once the second is paid, then you move on to the third. That's why known as a waterfall, so like a cascading effect. Then the fourth category is where the financial debts owed to unsecured creditors. So you see the unsecured creditors will stand at the fourth position. Fifth position, again ranking equally. So all of them are on equal footing, is the amount due to the central or the state government in last 2 years. And the debts owed to secured creditors, whatever is left after 52, we will discuss 52 also. But anything which is there left in payable to them, to the secured creditors under section 52. So here again the dues to the central and state government only in the last 2 years. If there is anything beyond that, it will go to the next position. It will not be covered here. So only the 2 years dues are priority. So again, see the difference here. The preferential debts, what used to be earlier, are now ranking at the 5th position. Now the 6th is any remaining debts and dues. So here all your OCs, your workman dues beyond 24 months, employee dues beyond 12 months, or your government dues beyond 24 months, all those will come in the 6th category. Then we go to the 7th, which is the preference shareholders. And then we go to the 8th, which is the equity shareholders. So this same distribution is applicable in case of a voluntary liquidation also. So we need to follow section 53 priorities. Typically in a CRP liquidation, I don't think you may reach beyond the 2nd or the 3rd position unless the company has really good assets. But in case of voluntary liquidation, you have to reach the last position because that is where your debts are less than your assets. So in a voluntary liquidation, you're going to deal with everything. But in case of a CRP liquidation, you may not reach the 2nd or the 3rd category. Now, one more thing to be noted here is that even if there is any contractual arrangement inter se between the parties, saying that instead of me, you take the money first or whatever, that will have to be disregarded. We cannot take cognizance of those inter se contractual arrangements. We have to go exclusively by section 53. And in case the fees are at each stage, the fees what are payable to the liquidator are going to be deducted proportionately from the proceeds which are payable at each stage. So it can't be that suppose a liquidation is expected for 12 months. The liquidator withdraws his entire fees at the first instance and then nothing is left for distribution. So for each stage, for each category, proportionate fees will be deducted from the amount which is payable. Now, one important option to secured creditors in case of a liquidation, that is section 52. So a secured creditor, one whose charge has been registered with the ROC. So that is very, very important that the charge of that particular creditor is registered with the ROC, then only he can be categorized as a secured creditor in the course of liquidation. Now, if such a person is there, such a creditor is there whose charge is registered and he is categorized as a secured creditor, he has the option to say that I am not joining the liquidation pool. I am not going to pool in the assets which are charged to me exclusively. I am going to sell those assets on my own. I will contribute to the liquidation cost, whatever is my share of the liquidation cost. I will contribute to the payments to the workers, what is attributable to me. But apart from that, I'm not going to come in and put in anything in the liquidation estate. I am going to sell the asset which is charged to me exclusively. I will sell it and I will take the money subject to these two deductions. So a secured creditor in that sense has that particular right, which he needs to inform upfront when he's filing his claim to the liquidator, and in the first 30 days, he has to opt at that time itself, saying that I am going to realize my assets on my own. However, if he's not able to realize those assets within a specified period, say 6 months, then those assets will revert back to the liquidation estate, and then the liquidator will have to sell them. So that he gets only a 6 months period. So all these are later amendments. In the beginning, these provisions are not there. So once a person opted under 52, he could take whatever time to realize the asset under 52. And the liquidator did not have much to do in that sense. But now with this timelines being brought in, and mind you, the timeline for liquidation is 12 months, which is in very few cases we can achieve that. But the statutory time limit is now 12 months from the date of liquidation commencement. So here again, the liquidation, if the secured creditor opts to realize his security interest outside, he will sell the assets, he will give his contribution towards the liquidation fees, the liquidation costs. He will give his contribution towards the workers' dues, and he will take the entire money. So this is something which is, yeah.
Sorry, but is this a retrospective amendment or a prospective, in the sense for cases which were like liquidation started in 2019, and that time if the secured creditor had kept it out and still today he's not able to sell, so will this new regulation be applicable, or it is, since it is,
it's not applicable? But in this case, what we do is we go under section 60 subsection 5 to the NCLT and saying that because of this person we are not able to close the liquidation because that asset is not realized. So you either direct him to sell within a reasonable time or let that asset revert to the liquidation estate, and the NCLT grants that approval. But there's no retrospective effect of that 2019 amendment.
okay.
I am suffering
Thank
in
you.
one case for last 4 years because of that.
So
But-
honestly, same with me. That's
Yeah.
why I asked.
So we have recourse under section 60 subsection 5. So this section 60 subsection 5 is such a wonderful section. You can put anything under the sun and get any order in that sense from the NCLT. So I think that's a wonderfully drafted section, and it's really handy. So I have been able to recover from debtors who are not entities, so partnership firms and everything. I've been able to recover that, and NCLT does pass those orders. So I think it's a wonderful section, and we should make maximum use of that particular provision. Right. So coming back to section 52, now life has become simpler in that sense when somebody goes or opts under section 52. But provided that security interest is verified, we have to say as liquidators that yes, this security interest is verified, and you allow him to realize the asset under section 52. Then again, if once he realizes those assets under section 52, if there is a shortfall which is there, suppose he realized 100 crores, but his outstanding is 120 crores. For that balance 20 crores, he can come and stand in line here at the 5th position. It says debts owed to secured creditor for amount unpaid following enforcement of security interest under 52. So that balance 20 crores, he will come here. But if he realizes extra, if he realizes some higher amount, that additional amount has to be deposited with the liquidator in the liquidation estate. So those provisions are already there. In case he files any resistance, if he feels that there is any resistance from the corporate debtor or from any other person in realizing the asset under 52, he can that secured creditor can approach the NCLT for say seeking possession or whatever it may be, and he can get appropriate orders passed in his favor in that sense. Then of course he's supposed to pay the unpaid resolution process cost and the amounts due to the workers, whatever is his share that he needs to contribute, and remaining amount he can keep with himself. So this 52 is handy only in case there is more than say 2 or 3 secured creditors. If there's only one secured creditor, then it may not make much difference whether he's opting for 52 or 53, because in any case, everything is going to come to the liquidation estate only. One more thing is under 52, again, of course, I spoke about the timelines and those things. But coming to sale of assets under this, under the liquidation regulations, recently a lot of changes have come to the auction regulations. The timelines and everything have, which were not there earlier. So minimum how many days need to be given and all that. So that schedule to the liquidation regulations is amended. That regulation 1 is amended. So we need to be careful about what are the timelines which are given and all that. So make sure that you read that whenever you're coming with an auction for sale of assets. Yesterday, there was one case which was reported in this IBC laws, which says that it was an old case before the 2022 amendment, where the liquidator has not given sufficient time. He concluded the entire auction within 7 days. So where the NCLAT has held that this is not reasonable, at least a reasonable time, say 30 days needs to be given for that entire auction process. This shows the hurry in which this, or some other considerations in for which this liquidation was, or this auction was conducted in such a short time. So make sure that you are adhering to this, the timelines which are given for the auction. And also time to time, we need to keep making submissions on the IBBA website. This auction notices need to be published there. All your public announcements need to be published there. So make sure that you are complying with all of those things. At the end of this process, once all the assets are realized, especially debtors, which can be very tricky, how to realize the debtors. So have a strategy in place when you are going for the liquidation itself. If you are continuing as the RP, then you know from first itself what are the debtors and what problems you're going to face. So make sure that you have done whatever it takes to either write off those debtors, if it's not possible, say based on the valuation report, or any actions to be taken for realization of those debtors. So you can swiftly move towards the dissolution of the CD. Again, for dissolution, you need to give that compliance certificate saying you have complied with all the provisions, and file application to the NCLT and get the dissolution order. Sometimes the NCLT is considering that in case of a dissolution, if say some case is pending somewhere, but for that case, then the dissolution may be allowed, although those cases are rare, but yes, people are filing applications for dissolution in such cases. Right, so this was about the liquidation. One other thing which I need to highlight is the pre-pack. Although this has not come out in a very big way as expected, but then this pre-pack is something which can be utilized. So when we are even advising our clients who are MSMEs about how to get a reorganization of their loans in that sense, then this is a a good tool, so which gets the courts backing, because again, if you see, sometimes the banks themselves are reluctant to give a restructuring of the loan because of their own internal norms, and with so much of pressures on the managers to ensure that everything is compliant and no fingers are pointed out to them later on. Banks may be reluctant to reorganize or restructure certain loans. So pre-pack may be a good mechanism where we, it's kind of a parallel to section 10. Only difference is that this is only for MSMEs and the minimum default amount should be only 10 lakhs. So it's really handy for MSMEs if there is a company which is actually in such a position. Again, the debtor retains the control here. So there's a paradigm shift from what is the basic tenet or in the IBC, where it's the creditor in control mechanism. But only for pre-packs, they have brought in the debtor in control mechanism, where the debtors continue, the suspended directors such, the powers are not suspended. They will continue, the promoters will continue to run the company. Only the RP will be there to monitor the process. So we don't have to run the process. We just have to monitor the process as RP is there. And again, the resolution plan and everything is will be there as per the process. What we do usually. Only thing is, at the beginning of the process itself, the MSME will say that this is the plan what we have, and then the CD also, the COC also has the option to ask for plans from third parties. So then the best plan will be considered. So at least there is some assurance that at least the plan from the MSME will be there. So in that sense, even the COC may be more in favor of going for a pre-pack mechanism if some company wants to opt for it. And of course, everything happens under the control and the directions of the NCLT. So the whatever plan is there and whatever restructuring of the loans will happen, that will happen with the under the stamp of the NCLT. So again, the banks need not worry much on that front. Again, if this resolution plan does not go through, then the option is not liquidation. The company just comes out of this pre-pack mechanism. So in that sense, the closure of the company also does not happen. So in the true sense, it is a chance for revival for MSME, if we may put it that way. So I think maximum people should take advantage, although I think there are hardly no cases which we can count on the tips of our fingers. Pre-pack has not got much success in that sense. Only in case there is a fraud or something which is detected during the course of where we need to do a PUFE. If such a case does come out, then there is going to be a takeover, and those provisions are given in the section. I think section 54 is there. Those provisions are made, but that is only in case such transactions are detected. Otherwise, I think it's a very normal run-of-the-mill affair. The only drawback which I see here in terms of pre-pack, in terms of the resolution plan, is that the plan, the provisions say that no haircut can be allowed to be given to operational creditors. The FCs can take haircut, but the OCs cannot be given a haircut. I think that is the reason why it is not taking off the way in which it should. But maybe re-looking at those provisions, it might make this preferred option for MSMEs, because giving a haircut to FCs is okay, like, we understand that, but not giving any haircut to OCs may not be acceptable. Many a times the plan is submitted so that you get away with some of the, not paying certain OCs in that sense, especially the government dues and those things. So that is maybe something which is holding back the success of the pre-pack. But I think with what we are hearing is with the overall of the IBC, which is coming in the next few months, I think this provision will also be relooked at and maybe make it more workable or make it more appealing to the people to go for this pre-pack mechanism. So now the last part in that sense, coming to the voluntary liquidation, I'm just covering it briefly. This is like a refresher course, so only the basics. So even though voluntary liquidation, the basic premise is that the company is solvent, still it is covered in section 59, read with the voluntary liquidation regulations of 2017. Companies and LLPs both are covered in the voluntary liquidation. So even the LLPs, you need not refer to the LLP Act. Now you have to refer to the IBC only, section 59 and the regulations. And the NCLT is passing orders. I have been able to close few LLPs and few companies. And it's a very simple process as compared to, of course, the CRP and the liquidation. So it's applicable to all types of companies and the LLPs. So generally when we go for closure, we say that the last 2 years, if we are going for a strike-off, last 2 years, the company should not have carried on any business or those things, nothing of that sort. As long as you're able to give a solvency declaration, whatever may be the status of the assets and the liabilities or the operations of the entity, you can go in for a voluntary liquidation. Prerequisite is the solvency declaration. Draw up the balance sheet to a latest practicable date before the board meeting is held for the solvency declaration, or the shareholders meeting for in case of a LLP. Make sure that no, when you are acting as a voluntary liquidator, then make sure you have all the information about the list of the debtors, list of creditors from whom the money is going to come. Typically, these the foreign companies generally will go for this, subsidiaries of foreign companies where they want a clean exit and a complete exit. Indian promoters still prefer to go for the, of course, this is a generalization, but they might prefer to go for this strike off road. But foreign companies, they generally want to get a clean and complete exit. So they will, and those books are generally clean also, if we look at it in that way. So voluntary liquidation process is much simpler in those cases. The solvency declaration will be given based on the latest financial statements, which may or may not be audited. At least last 2 years needs to be audited. You can have a provisional drawn. If it is during the year, and if after the last AGM, say suppose it was for 31st March 22, during the year after the AGM was held, you can start the liquidation anytime. Since now we are in the steps where the financial year has completed, 31st March 23, then you should go for an audited financials for March 23, hold the AGM, and then go for the voluntary liquidation so that your books are updated. You complete the filing for this year, and then you go for the resolution for liquidation. Make sure that, again, again, a practical thing with the way MCA site is working nowadays, and you will not be able to complete the filings if the AGM and the special resolution for liquidation is passed in the same meeting. So I have 2 separate meetings. Complete the AGM, complete the filings with the ROC, complete everything else which is to be done. Especially if there's going to be a change in director or something, make sure that all the forms are filed beforehand. Because once you file the form MGT 14 for voluntary liquidation, you are not able to make any changes. So kind of practical experience which I've had recently with the V3 version. Make sure that all these things are completed. You get the solvency declaration. Within that, within 4 weeks, you need to pass the resolution for your voluntary liquidation. On the date of voluntary liquidation, you will be appointed as the liquidator. From that, your tenure will commence. Again, you need to make the public announcement, ask for the claims. Again, within 30 days, you need to invite those claims. Under the relevant tax laws, say under the GST Act, under the Income Tax Act, there are provisions where you need to intimate those authorities about the commencement of liquidation. Say 178 of the, I think it's 178 of the Income Tax Act, which says that intimation needs to go to the officer concerned. Then he will file the claim. So if that intimation is not sent, then there's a lapse on your part. So you cannot rely only on the public announcement, because these documents, when you're ultimately filing the application with the NCLT, you have to attach all those documents to the NCLT application. In the voluntary liquidation process, the NCLT is not involved at all unless you file the final application. So this is something which is completely only in your control as the liquidator. You need to take decisions and you need to take the steps, whatever is required, as which is given in the liquidation regulations. Voluntary liquidation regulations. You need to have a separate account for a voluntary liquidation. Either you convert your existing current account of the CD to a liquidation account or open a new account, up to you. Then, of course, filing of those, making the announcement, receiving the claims. In case the company has creditors on the day when the solvency declaration is filed, then you need to have a creditors meeting also. The creditors also need to pass the resolution with 2/3 majority and pass the resolution for liquidation. So ensure that when you are being appointed or if you are advising somebody, if you see creditors in the balance sheet, make sure that that meeting is held. Else that commencement itself may be void ab initio. 30 days is the timeline for claims. If no claims are received, then the timeline for completing the process is 90 days. If claims are received, then the timeline is 270 days. It is generally doable. Even I have been able to close a case in 92 days. Of course, that is where we give the final report. Whatever time the NCLT takes is not counted in this timeline. So we file our final application, our resolution application, and our job is done in that sense, and wait for the hearing. But these timelines are actually practicable. The only challenge sometimes what we may face is getting the income tax clearance, especially in case of foreign companies when the money or surplus is to be remitted abroad. In case of Indian company now, the IBB has brought out that circular some time ago, that income tax clearance is not mandatory. However, for foreign remittances under the FEMA reciprocal arrangement amendment has not been made. So the banks, some of the banks still insist on getting that income tax clearance. So the only challenge could be getting that clearance. Otherwise, unless there are a lot of assets in the company, the process is generally smooth. Not fraught with a lot of litigation, because it's a voluntary thing which is being done. Creditors' consent is taken, shareholders' consent is taken. We know who the creditors are, we know who the what are the assets. We need to realize all the assets and pay off all the liabilities in accordance with section 53, because that is the essence. We have funds, we are saying we are solvent, so all the liabilities should be paid off. Surplus in the account is to be paid to the shareholders. So again, equity preference, as again, if there are some agreements which are there in the parties, then we may have to take cognizance of that of the priorities, unless it is falling foul of section 53. The last step in the process is the closure of the liquidation account. All these documents and the final statements, making the receipt and payment account, the closure report of the bank, all that has to be annexed to the final resolution application. Our final report will go, of course, in the interim of the preliminary report, and those things will have to be filed. The final report will go to the NCLT along with the NCLT application, and also to be filed with the ROC. Now the ROC clearance as such is not required. We don't need that form to be approved, but it's always better if that form is approved when we are standing before the NCLT. In each NCLT in that sense has a different practice for voluntary liquidation, which is what I realized. Mumbai will follow different practice, Bangalore may follow different practice, where notices of the petition to be given to ROC and other authorities. So NCLT Mumbai doesn't have that practice, that we need to serve a copy of the petition on the ROC, but Bangalore follows that practice. So before you're filing the application, make sure that you know what the local practices are of each NCLT, and accordingly you can take the steps, because otherwise you waste time in that. Even though your final report may be ready, filing of that application may take time in that sense. In case somebody wants to challenge, or if you as a liquidator, if you feel that this solvency declaration itself was incorrect, maybe you received claims, and I've seen a couple of cases, not with me, but with my other known IPs, where the claims were received in the course of voluntary liquidation, and the claims amount were more than the assets which were there available with the company. So in that case, then the solvency declaration itself, maybe you can't say it was incorrect or with some any other intention. Maybe the claim which was something which the directors were not aware of, whatever the reason may be. But in that case, as a voluntary liquidator, you need to approach the NCLT saying that now this liquidation cannot progress. So make sure that once the claims are received, check the solvency position again before you move on to the next step. The bank account should be in your control. Payments, the receipt and payment statement needs to be audited and certified by a chartered accountant who cannot be a statutory auditor. Again, all those things are there as per the liquidation regulations, which are there similar to our regular liquidation, that is a CRP liquidation. But it's a very simple process. So somebody, you're not very keen on going for a CRP, acting as RPs in CRPs, then this liquidation, voluntary liquidation, is definitely something good to start with, and which will give a little bit of a flavor, although you can't really compare a CRP liquidation with a voluntary liquidation. But to act as IP, that is one of the first steps with which you can start. Now this is with the regulations. Now I have only a couple of slides about the opportunities what we have in IBC, not only as an IP or as a liquidator, but other things which we can do, irrespective of whether we have that registration with the IBBI or not. So acting as IP, of course, acting as representative of the financial creditor on the COC, acting as authorized representative for class of creditors, then acting as liquidators, voluntary liquidators, and registered valuers. So all these things for which you need to be registered with the IBBI, clearing that exam and all that. But these other things where you can appear before the NCLT to represent any of the stakeholders, the parties, any interveners, you can do that. Drafting of resolution plans, drafting of these legal documents for the RP in case somebody needs help. Then acting as a transaction advisor, doing the forensic audit, helping the RP. Acting as process advisor. So some RPs do take help, or some banks insist that the RP should take help of a process advisor as a support to the RP or liquidator. So in that case, that is another area of practice. What we can do, where we have decent knowledge of the IBC and the practical aspects. Apart from that, maybe even in your regular practice, you can advise your companies or your, if you're in employment or in practice, advising your clients about how to recover the outstandings from your debtors, say sending demand notices, what would stand, what would not stand, filing of cases in the NCLT on behalf of your clients. How you can advise your client how to avoid any action against your own clients if there are outstandings to others, and how they can avoid maybe actions, how to create that record of pre-existing dispute and all those things. So basically value-added advice which you can give to your clients. Many companies don't know how to file the claims in the course of CRP or in the course of liquidation. Then so you can help them in filing the claims or advising them how to go about the entire process. Sometimes the banks are not very conversant with what steps to take. So even though you may not be acting as a representative, you can act as an advisor to these banks about the resolution process as such. Drafting of resolution plans or helping in acting on the monitoring committee on behalf of the CD, on behalf of the financial creditor. All those things as a representative, all those things you can do. There are many companies who may be your clients who are cash rich or who are looking for these investment opportunities. So going to the IBBI website where you see all these auction notices, or you see the Form Gs which are coming there. Taking note of that and then advising your client who may be in the same business or is looking for investment opportunities or acquiring such companies. So you can give these services, and along with that, maybe you can add all these things, drafting of plans or advising them how to go about a 230 mechanism, say for example, merger amalgamation in the course of CRP also, or acquiring as a going concern in the liquidation. All those things, value-added things you can advise. So this was a little bit aside, not on the provisions of the code as such, but I thought maybe just different areas which can be explored, which can be discussed. So this is what I had from my side. In case anybody has any questions, we can take that, or if you want to add something also feel free, your own experiences, else we can conclude.
Thank you, ma'am, for this insightful session and giving us the information and the knowledge, sharing your time, valuable time with us. Participants, if you have any question, you may please unmute yourself and ask from the faculty.
Somebody had asked for this presentation. I'll be circulating that to the IPA, and then they will in turn be circulating to the members, to the participants, I understand. I guess there are no questions. I'm aware it was a very long session and a lot of things, but then 3 hours covering the entire. So as a refresher, it's okay, but it's a lot of information in three hours. So I think even my throat is parched now. So I think we can call it a day. And,
No, job very well done, ma'am. Thank you very much.
Thank you. So,
so on behalf of ICSI IP, I would like to present formal vote of thanks to today's faculty Anagha ma'am for sharing her time with us and the knowledge which cannot be expressed in words specifically. So thank you, ma'am, for sharing your time and knowledge with us. Thank you, ma'am.
Thank you for the opportunity, and thanks.
Thank you, ma'am.
Thank you. Bye.
Participants, we're going to meet by 1:30 again with the another faculty. So this is a lunchtime. We can have a break for 1 hour. We'll meet 1:30.
Thank you.
Okay.
Thank you.
Very